Court, Judge Capper here. We have reviews to do first, and several of them, so if you're here for that, your name's going to get called. Come up to the table to your right. I'm reviewing your file to see what efforts you've made to complete your order. So if you don't get called, then you should have, go check in with the clerk, because if you missed a hearing before, we don't know you're here today. Call reviews.
David Abrams, Daniel Bryson, Thomas M. Burton III, Alexis Kane, Amanda S. Hyten, Branson Johnson, Shannon L. Lewis, Leah Mayor.
David Abrams is here, 20-21-97. Community service is done. Now you just have to get your fines paid.
Yes, sir.
And these are OVP. And you have a report. Okay. Looks like you're compliant with what they're asking you to do. Can you make any payment on your fines today?
Yes, sir.
How much are you paying?
40.
Okay. See the clerk to make that payment. September 20th will be your next hearing. 9 a.m.
Thanks, sir.
Thank you, Your Honor. Daniel Bryson.
Your Honor, if I may?
Yes.
This gentleman was the one who had went to TCC for detox.
Right.
The Saturday before he was to get released from TCC to go to jail, he tested positive for COVID. The jail refused to take him.
Okay.
So then he was still, I gave him a week, then he was still having COVID symptoms, so I told him to come in today. He still has an ankle monitor on. So he's here reporting today for the review hearing and report to jail, I'm assuming.
All right. So he went to detox, but he never made it to the jail.
Never made it to jail, yeah.
All right. Command him into custody. He had a 35-day jail sentence. I'll review this again. September 6th. So I'll put him on the docket for September 6th. He'll be in jail then, so.
Can I speak with my wife before?
No, you we'll talk.
So ankle monitor will have to be removed.
Yes, I'll notify them today, they'll take off.
Thomas Burton III. 22-352-2566. Thomas Burton.
Your Honor, he wasn't in community service when order was.
Okay. All right, he's failed to appear today, so there'll be a bench warrant for failure to appear. Alexis Kane, 23502. She's at Bethesda. Got a report. It's a good report. Community service is done. Your files are almost finished. Okay, let me see her judgment entry. 23502. Okay. Well, you're doing well. Good job. And continue. She's not finished with treatment. Continue with that. And we'll give you a little more time since you're doing so well before you have to come back. Does it matter with your work schedule, what day of the week got scheduled? You just have to ask off?
Yeah.
Okay. It'll be in September. Make it September 30th. That's a Monday. Okay, good work.
Thank you.
Amanda Heitman.
Hello.
You're Amanda?
Yes, sir.
153774, 132791. You still have community service to do?
Yes, sir. I just started a job and I'm going to start making regular payments and I can do community service on Saturdays.
Okay, tomorrow?
Yes, I can.
All right, Mr. Cooper's going to put it down and expect you to be here. Are you making a payment on your fine today?
It'll have to be a little bit later, but I can today.
Okay, you got to get here before 4.
Okay.
How much will it be?
I can do 50.
Okay, get to the clerk's office before 4, make your
Okay.
payment. These are both very old cases, so you've got to come back pretty quickly. So it'll be a month out.
Okay.
September 16th will be your next hearing,
Thank you, sir.
9 o'clock.
And community service is on what time?
7:30 in the morning on
Okay,
the west
thank
side of
you.
the building.
Okay, thank you.
Branson Johnson. Branson Johnson is 21,795. It's not finished, hasn't appeared, so the warrant issued. Shannon Lewis. 23,427, is that Bethesda?
Your Honor, he's completed our program, graduated, I think, about a couple weeks ago. We've also sent up a paper that from the BMV asking to have his tag removed.
Could I get the yellow tags? You said 6 months. I'm gonna see if I can get a regular tag put back on my car. The Ohio BMV's fine with it. They just said you had to sign off on that paper.
Okay, where is it?
It was with the paper that she gave you.
Sure.
Intoxilox took the breathalyzer out of my car. They said it had been 6 months, and I was just wondering if I could get the yellow tags off in 6 months.
Okay, your suspension actually was over April 24, so.
Yeah, but I had to drive with the yellow tags and the breathalyzer for 6 months after I got my license. And this month makes 6 months. They took the breathalyzer out Wednesday, the 14th.
This actually says application for registration of a motor vehicle with restricted plates.
Yeah, I got the yellow plates on my car. They said that one thing they need was you to sign off on that. And then I could transfer my yellow tags for regular tags.
It doesn't appear to me that that's what this would do. It appears to me this is an application to allow you to have restricted plates, not to remove them.
That's what the lady at the BMV gave me and told me that that's what I had to have to get them taken off.
Okay, well, here's what I'm going to do. I'm going to let you and Mr. Major
Okay.
do some research on that, because I don't think it's gonna accomplish what you want it to do. So you can talk with him about it, and he can call the B&B.
Okay.
If it is correct, then I can sign off on it, but it doesn't look to me, it looks to me like that's what should have been done to get you the restricted plates.
I don't know, she pulled something up on the computer and handed me that paper, so that's what,
So if you want to talk to him today, if you can get something.
Okay.
I mean, I'm going to be doing court, but set your next hearing for September 30th.
Okay.
Thank you, Your Honor.
thanks, sir.
You're welcome. Leah Mayor, 23671. Okay, it looks like you've done your community service, paid your fines and costs. The only thing left to do is the driver intervention program.
Yes.
Tell me about that.
Well, I was actually supposed to do it in July. I would put my name on the list in June, but I think a miscommunication happened. They were supposed to get a hold of me with information, but they didn't. So by the time that I had called, the class for July was already over, and I couldn't afford it to do August. So I'm hoping next month that I can do it.
Okay. And you're doing the one here in Lawrence County, or where?
Yes.
Okay. Well, I'm going to set you in October then to give you a chance to do September and October school.
Okay.
Do you know what the dates are for the schools?
I don't. I have to get a hold of them again.
Sometimes there's somebody here from the school, but I don't see anybody here today. Okay, I'm going to set it for October the 18th. I think that would give you 2 chances to get it done. If you get that done, filed with the court, you don't have to come back.
Okay.
Because that's the only thing you got left. October 18th, 9 o'clock.
All right, thank you.
You're welcome.
Jessica Ward Prince, John Smith, Tony Walters, Sarah A. Woods, Glynn R. Logston, Kristen M. McAllister.
Jessica Prince.
She is not here, Your Honor.
She was compliant for a while, but is not compliant with OBP now. She hasn't appeared and hasn't finished what she was ordered to do, so I'll issue a warrant for her for failure to appear today. Thank you. John Smith, 16429. Okay, you have done some community service in July toward your fines. Do you have a payment today?
Yeah, I have 40.
Okay. See the clerk, are you working now? Or
Yeah, I'll work at Giovanni's right there in South Point.
Does it matter if it's Mondays or Fridays for your next hearing?
No, I go in at 4,
Okay.
work at night.
All right, October 16th, I'm sorry, September 16th, September 16th.
No.
You get it paid off, you don't have to come back. You're within striking distance of getting that done. Sarah Woods, 22,326, 21,686. Sarah Woods.
She's on telephone.
All right, Sarah Woods is appearing by teleconference. Okay, there's still a lot left here to do. You've got 60 hours of community service left to do.
I am moving out on Tuesday, and I just got my driver's license this past Wednesday. I'm getting a vehicle, so I'll be able to get that taken care of. And I am going to be making a payment today. I'm hoping to have this taken care of in the next few months, like all paid off.
Are you still at Mended Reeds?
Yes, sir.
Okay. Can you verify that she's at Mended Reeds?
Your Honor, I am appearing by Zoom, Brandon Peters with Mended Reeds.
Yes.
I can confirm that she has been compliant and she is successfully completing and moving out of transitional on Tuesday the 20th into her, what I believe to be her own or maybe even a shared residence, but she is moving on. I have been able to verify the information that she stated. Her aftercare plan was approved by Mr. Major as well as Mr. Carl Bowen over at the Common Police Courthouse. She is continuing to follow up services with us afterward as well, I do believe. So she is currently on track, and I can verify everything that she has said to this point.
All right. Thank you, sir. I'll set your next hearing, ma'am, for September 30th. That's the last Monday in September, 9 a.m.
Okay.
Okay. Good luck.
All right, thank you.
You're welcome. Lynn Logston, 24554 Lynn Logston. Not appeared, hasn't done anything on the case, so it'll be a bench warrant for failure to appear. Kristen Mallister, 24203s at Southern Hope. Okay, says she's fully compliant and doing what she needs to do there. Have you got a job yet, or what's the?
Yes, I work at Regal Recovery Center. I will
Okay.
start getting paid next Friday, so I will start paying my fine
You
off.
just started there? Or?
Yes,
All right, well, good job.
thank you.
Set your next hearing, September 20th. 9 o'clock.
All right, thank you very much.
Thank you. You're welcome. Yeah, your case actually is on the, should be on the pretrial docket, so just have a seat. And Mr. Smith is your lawyer, right?
Yes.
He also- Okay, we're going to start the arraignments now. Arraignments are the first hearing. When your name's called, come up to the table to your right, stand there. I'll go over the charge with you, which the prosecutor decides what's to be filed. I don't decide that. So you don't have to agree with it. It may not be true, but you need to understand what you're charged with. So that's what I'm going to explain to you, what the charges are. Possible penalties, and you don't have to say anything. You can remain silent. You have that right. If you want to say something, though, it's all on the record. So what you say is being recorded. If you admit something about your case, the prosecutor can use that against you. You have a right to have an attorney, to have one appointed if you can't afford one. You have a right to bail, and to make the state prove any charge beyond a reasonable doubt. If you enter a guilty plea, you're waiving those rights, or no contest plea. So you shouldn't do that if you don't understand what's happening, if you're confused, if you don't know what to do, if you want to talk to a lawyer, if you want a trial. For any of those reasons I just mentioned, you should enter a not guilty plea when you're asked. Don't enter a guilty plea or no contest plea to get it over with. That's not a good reason to enter one of those pleas. Call the first case.
State of Ohio versus Mason S. Kazy. Case number TRC 241654, A, B, and C.
Sir, are you Mason Scott Kazy?
Yes, sir.
Mr. Kazy, it's alleged August the 11th at 2:53 a.m. Union Township, you were operating a vehicle after consuming alcohol underage. That is a 4th degree misdemeanor, carries a maximum penalty of 30 days in jail, $250 fine. There is a mandatory 90-day license suspension if you're found guilty. State's alleged you took a breath test and tested 025. So this charge is, it's a subsection of the regular OBI section, but it's for people under the age of 21. So there's basically zero tolerance for alcohol consumption for anyone under 21 because it's illegal to drink alcohol under 21. So your test score is actually rather low. It would be if you were over 21, but it's the per se level under the statute you're charged is 0.2, so you're just 5/100,000 thousandths over it, but you're slightly over. Do you understand the charge and the possible penalties?
Yes, sir.
You're also charged with a turn signal violation and a tail light or license plate light violation. Those are both minor misdemeanors. Maximum penalty is $150 fine, no jail time.
Sir.
Do you have any questions before you enter a plea?
No, sir.
What plea do you wish to enter?
Guilty.
Guilty means you're admitting it's true. You waive the right to have a trial and have a lawyer if you enter a guilty plea. Do you understand that?
Yes, sir.
Okay. I'm going to read what the officer wrote to the court. Then if you want to make an explanation or statement, you can. You're not required to. Okay, the officer says August 11th at approximately 2:53 a.m. I saw Dodge Durango, black in color, driving State Route 7 bypass with the defective plate light. Witnessed use of a turn signal when entering a new lane. The vehicle failed to use the turn signals that entered the new lane hanging on the ramp. I did a traffic stop at State Route 7 Milepost 1. On making a driver's side approach, I contacted the driver, Mason Kazy. There was 2 passengers as well, asking for his identification. He struggled to find his registration, asking where they were coming from. He said Huntington, asking where they were headed to. He replied heading home. I was about to stop at Speedway because I'm low on gas. I asked him where they were coming from in Huntington. He says we were just driving around. He found the registration, asked him for a few minutes, went back to the patrol car. While checking his license, Trooper Beam advised that he spotted alcohol hidden under the rear seat passenger's feet. I investigated further. Mr. Kazy asked if he could see where the license plate light is out. After letting him out of the vehicle, see his defect, I proceeded to ask him to be honest with me about where he'd been. Told me they were just driving around. There was a fraternity in Huntington, so we went and checked that out. Asked him if he'd been drinking, to which he replied no. There was a faint odor of alcohol coming from Mr. Kazy while he was separated from the vehicle. Asked him if I could check his eyes, make sure he's okay to drive. After conducting a check on his eyes, asked him a series of questions prior to the field sobriety test. Was given a portable breath test and tested 029. Was given an arrest for operating a vehicle after consuming alcohol underage. Transported to the patrol post and agreed to give a breath test and tested 025. Released to a parent. Okay, anything you want to tell them?
Just about the situation or about myself or?
Whatever you want me to consider before I do the sentencing.
I do go to university. I'm not like nowhere around here. I go to university in England. I play soccer over there as well. And I go back pretty soon. I leave in about 2.5 weeks, around the 7th of September. And right now I have a full-time job at the airport, working there for the summer. So that night it was just an honest mistake, and I learned my lesson from it.
Okay, well, you had a pretty low level of alcohol in you, but it's still, because of your status of being under 21, it's still a violation under Ohio law. It is, I have to give you at least a 90-day license suspension. I can give you driving privileges after 60 days. I don't make the law. The legislature makes the law, so that's what they provide. Does the state have any input on this?
That is a low score, given the circumstances. We wouldn't take any exact position on sentencing. I didn't listen to everything that he said about his circumstances, but it sounds like he's not going to be here.
He's a student and he's going to England.
So we would not oppose if the sentence took that all into account.
Okay. All right, so what I'm going to do is I'm going to give you basically the minimum. I'll give you a minimum. I'll give you a fine of $25. Order you to pay the court costs. Your license suspension is 90 days. It'll start the day of the incident. I'll give you a permit to drive after 60 days. Now, I don't know how, I've never had anybody go out of the country with a permit. So, do you drive when you're in England?
No, I don't.
That's not going to be an issue.
That's not going to be an issue.
Okay. If you want to get the permit, what it is, it's just a judgment entry from me saying you're allowed to drive. If you're not going to be driving, I guess it wouldn't be necessary, but it seems to work here for other states, because what would happen is going to show up on your printout. You have an Ohio license. It's going to show up there as being suspended, that you got this permit from me saying you can drive under certain circumstances. So if you want to get that, you can. If you don't need it, then I guess it's necessary. Now, one thing you will need to take care of, because you're getting a license suspension, it doesn't automatically reinstate when the suspension's up. You need to contact the Ohio BMV, that's the agency that issues driver's license. At least you'll have to pay a reinstatement. If they'll require you to do anything else, that's up to them to reinstate your driving privileges. And you're not going to be eligible to get reinstated until November the 9th would be the last day of your suspension. So, I don't know if you come home for Christmas or that might be a good...
I won't even be home then. I won't be home till Christmas. So.
Okay, well, that's what I was saying. When you come home for Christmas, maybe a good time to contact the B&B and say, I'm home, what I got to do, or maybe even before then, if you want to drive while you're here, to get your license reinstated. It doesn't automatically reinstate. 10 days in jail. I'll suspend all of it on the condition you do the other things that I've ordered you to do. Pay your fine. I'm not going to require any community service. He's getting ready to leave the country, so. And you had a really low level test score, so I won't require any community service.
You want him on a level 2-year level 5 probation?
Yeah, we'll make it a non-reporting probation just to make sure you get it done. On the turn signal, $5 fine. On the tail light, license plate light, a $5 fine. I'll set your, so we set review hearings to make sure people do what they're ordered to. So you'll be home at Christmas?
Yes, sir.
I'll set it for December 23rd. You should be here then.
I think so. I should be, yeah.
Or I can set it after, in between Christmas and New Year's, which would be better.
That'd be better, actually.
Okay, December 30th will be your review hearing.
Yes, sir.
If you get everything done, paid for, you don't have to come back. So that really, that's all you have to do is pay your fine and court costs. check in with Mr. Major, he's the probation officer. He'll be over in his office to the left as you exit the courtroom.
Okay.
Do you have any questions?
No, sir.
Okay. Good luck with school.
Thank you.
You're welcome.
Thank you, Judge.
You're welcome.
State of Ohio versus Charles D. Porter, case number TRD 23240.
You're Charles Porter?
Yeah.
Mr. Porter, it's alleged you had a hearing on August the 5th that you failed to appear for.
Yeah, I got the dates mixed up. I thought it was the 18th and it was the 5th.
Okay. You are trying to get your license back, I believe?
I've done and got everything back.
Okay, if you got something to show me that?
Yeah, I got my driver's license right here.
It looks like it was issued June 17th of this year, so you can get, no. And you have proof of insurance.
Yeah.
What'd you have to do to get your license back?
I had to pay almost $2,500 and pay all my fines off and had to pay a reinstatement fee.
You got it done.
Yeah.
All right, so you'd already entered a guilty plea, and I had delayed sentencing to give you a chance to try to get your license back. You've done it, so I'm just gonna give you a fine since you've taken care of everything. I'll give you a $50 fine on court costs. Can you pay that today?
Yeah.
Okay, see the clerk, no probation, your case is finished by...
I can probably pay the $50 fine. How much is the court cost?
$125.
I could pay the $50 today.
But you can't pay the...
No, I can pay it. I just got paid, so
Okay, here's what I'm gonna do then. I'll give you a final payday. November 26th. So if you pay it before November 26th, it's all good. After that, it'll go to the B&B and they'll suspend you.
Okay.
for not paying. So you
Oh,
got-
it'll be paid for.
So you've got several months to get it done.
Okay, it'll be paid before.
Okay. Good idea to check in with the clerk and make a payment and then pay off the rest of it before November 26th.
All righty. Thank you, sir.
You're welcome.
State of Ohio versus Viola Pennington, case number TRD 172569.
All right, this is the lady that's at Southern Hope, and she has an outstanding warrant here on the littering charge.
Yes.
So you're Viola Pennington?
Yes, sir.
Okay, you've got a good report on your sober living now. So, do you remember getting this citation? Or?
Yes, sir.
Okay, tell me about what happened. Apparently you didn't appear at that time?
No, I didn't.
Do you have an explanation on that?
I kind of just forgot. I was getting high and stuff and really didn't pay no attention to it.
Okay. How do you plead to the charge? Is it, well, let me go through it. You're charged with on August 28, 2017 at 4:30. I'm assuming that's AM. Can't tell. We didn't mark AM or PM. In Fayette Township, you were littering. And got a copy of your printout. The officer says, traffic stop for a lane violation. During the stop, Viola threw out a lit cigarette and then lied about her identity. Okay, I tell you what. I think I can dismiss that based upon your good report, what you're doing with your recovery. That's a pretty pretty chintzy basis for, although I don't like people throwing cigarette butts out. And not
Yeah, I won't do it
report,
anymore.
But you're doing really well now. You were getting high then, now you're getting in recovery. So I'm going to dismiss this case.
Okay, thank you.
And keep doing what you're doing at Southern Hope.
I am.
Thank you.
Thank you.
You're welcome.
State of Ohio versus Vilma E. Gergely, case number TRC 23-1297, A, B, C, and D.
Year Vilma Gergely,
Gurgly?
you had a review on August 9th.
Yes, I thought it was the 19th. I do not know why. I think I remember there was a 9.
Okay.
That's why I missed my court. And then I have a couple hours left on that community service, but I found out they haven't sent it over. They told me they were gonna just send it over for me, but I guess I was supposed to bring it.
Where you
The animal shelter.
Oh, okay.
Yeah,
In Ironton or?
in Ironton. But I know I have like, I think 20 hours left.
Well, I'm showing some that you've done some.
Yeah.
Not as much as you say, but you need to get
Oh.
the report in.
Okay, so I have another issue. I was evicted from my apartment, so I have to move to Lexington today. And then I didn't finish all of this because I was working 2 jobs at the time, trying to keep up on the payments, but it did not work out the way I wanted to do, so.
Mr. Steyer, do you have anything?
I spoke to her this weekend, and I was telling her that if she's moving out of the area, she could speak to Mr. Cooper and make arrangements to find a place in Lexington to do the community service and send it back. I didn't know how the details of that work, but I know that's something that we do.
Yes, that's correct. So it sounds like there's some more hours that she hasn't been reported yet from the
Yeah.
animal shelter. So
Yeah.
you'll get credit for that. But they have to send it in. I'll set your, is it gonna matter, do you know what your schedule's gonna be, whether it's a Monday or Friday for your hearings?
I'm sorry, what was that?
Mondays or Fridays for your future hearings?
That should be okay.
Either way.
Yeah, either way, whatever, yeah.
September 30th will be your next hearing at 9 o'clock, that's a Monday.
Okay.
If you get everything finished by then, I don't think you would need to come back. Are we down to just community service at this point?
Yeah, well, I think she still has some funds.
Okay, well, you probably are gonna need to, especially if you're working elsewhere, you're gonna probably need to make sure you get back and make sure you get credit for that.
Okay.
So that's the day to be back.
Okay.
Try to talk to Mr. Cooper before you leave. I don't know how workable that's gonna be today with court going on, but I'd stick around at least a little while to try to talk to him.
Okay, that's fine.
Thank you.
Thank you.
State of Ohio versus Wendy Aldridge, case number CRV 24-511.
Ma'am, are you Wendy Aldridge? Bail's bringing you a copy of the charge. It's a theft offense from Walmart. It alleges on August the 14th in Fayette Township, you tried to deprive Walmart of property without their consent. It's a first-degree misdemeanor theft offense. Maximum penalty is 6 months in jail, $1,000 fine. Do you understand the charge? Do you understand your rights? How do you plead?
Guilty.
Guilty means you're admitting it's true. By doing that, you waive your rights to have a trial and have a lawyer. You understand that? I see you shaking your head. Yes. The affidavit is from a Mary Ann Bagley, who's an employee of Walmart. It says, I observed self-checkout register 46. I could see her switch tickets on 2 tackle boxes and skip scanning several items. The attendant was sent over, but she continued and left. 14 items were skipped, totaling $77.87. Anything you wish to say, ma'am?
I've never done nothing like this before. And I just recently went through a separation after 32 years. And I don't know why I done it, I don't know. But I cleaned houses for people for 31 years. I work every day. And I've never done nothing like that.
Okay. Well,
I don't know.
what I'm going to do is, because we get a lot of these cases from Walmart, and a big percentage of the people that I have that have shoplifted, maybe not you, have substance use issues. So I'm going to order you to go do a urine screen, and after I get the results, then I'll have you back and I'll send you.
Have a what issue?
Substance use.
No, I don't, but.
Well, I've been surprised before. I've had people I thought, well, I don't think this person has a substance use issue, and I had to go. I remember a lady that showed up from Pennington with very nice clothes, jewelry, a nice purse. Almost didn't make her do a urine screen. She kind of said the same thing you did. I don't know why I did this.
I mean, I don't
I
care
need
to
to have
do
her
it.
screen. You know what she tested for? Fentanyl.
I don't care to do it at all, but.
Go do your screen and come back. And if it's negative,
How does this work?
you're going to go to the bathroom and pee in a cup, and then they're going to test it and see what it shows.
Okay.
So go with Mr. Cooper. He'll show you where to go.
State of Ohio recall Shannon Lewis, case number TRC 427A and B.
Your Honor, we made several phone calls on this. The people we talked to couldn't tell us why he had that application.
Okay.
He contacted the local DMV, and they said just order from the court to remove it would suffice.
Okay. I'll do an order that since his driver's license suspension time has now expired, the special plates can be removed and he can be restored to regular plates.
Thank you.
So,
I have that case number.
If you just have a seat in the lobby, I'll take care of it.
Thanks, sir.
Mr. Major will assist you in that.
All right,
We'll keep
thank
it September 30th date. It's 23/4/27. And thank you, Mr. Gwynn, for the coffee.
State of Ohio versus Joseph M. Cardillo, case number CRB 24510.
Sir, you, Joseph and Cardillo.
Yes, sir.
Mr. Cardillo, the bail's hand you a copy of the charge that I'm going to read from. It alleges that Union Township, on August 12th of this year, you knowingly caused or tried to cause physical harm to Claudette Gibson. That's a first-degree misdemeanor, maximum penalty 6 months in jail, $1,000 fine. That's the most that can happen. Do you understand the charge?
Yes, sir.
Do you understand your rights?
Yes, sir.
How do you plead to this charge?
Not guilty.
You want a lawyer appointed to represent you?
Could I get one appointed to me?
I'm sorry?
Could I get one appointed to me?
Okay. Are you working?
Yes, sir.
Where do you work?
I work at Wendy's in Proctorville.
Are you paid by the hour there?
Yes, sir.
How much
I
per hour?
pay $10.45.
Okay, you're eligible for court-appointed counsel. I'm going to appoint Mr. Stratton to represent you.
Okay.
He's here, so this is Mr. Stratton. This is Joseph Cardillo. He has an M1 assault charge. Not guilty plea is entered for him.
Yes.
Since he's appeared on his own, he can sign a signature bond of $1,500. $1,500 OR bond. Is there a protection order requested?
Yes, Your Honor.
So, is it any problem for you to stay away from this lady, Claudette Gibson?
Yes, sir.
You can stay away from her, you don't live together or anything like that?
Yes, sir.
You're ordered not to go around her, don't contact her, don't post things about her on social media.
Yes, sir.
Just let things die down. No allegations of anything further happening between the two of you. That's what I want.
Yes, sir.
And then, Mr. Stratton, we're looking for hearing dates. Let me tell you what.
I work in the evening, so in the morning, best in the mornings.
It's always going to be in the morning.
Okay.
Monday or Friday.
I'm off on Mondays and Tuesdays.
Okay, Monday will be better.
Mondays are better?
Yeah.
Okay, it looks like we're into September then.
Okay.
September 9th?
Yeah, that'll work.
September 9th will be the next hearing.
Yes, sir.
It's going to be a pretrial at 10 a.m.
All right.
on September 9th.
I mean, that's fast as we try.
Let's walk outside. Let's walk outside. All right, thank you, Your Honor.
Good job. Okay, we are starting pretrials because we don't have any more arraignments. We'll have some from the jail. We may have some more from people here, but the paperwork's not ready. So we'll go to our existing cases for a while, then we'll come back to the pretrials, or arraignments. So we're starting the pretrial docket, so I need the lawyers that have pretrials. They're not going to be in the conference room. They're going to be out here in the courtroom, so you need to come in the courtroom.
State of Ohio versus Joshua Garberson, case number TRC 24746.
Mr. Holt's case set for pretrial.
Yes, Your Honor, he is on video conferencing, as you was discussed at the last time he was here. He is a Missouri resident that's currently residing or working on a railroad project along the Wisconsin-Minnesota border.
Okay, and we get anything accomplished at the pretrial?
I have received the hard copy discovery. I got the video today, Your Honor. Mr. Hill and I had some hopefully fruitful discussions regarding the case. Mr. Garberson is going to, I'm going to ask for a continuance, and during that continuance, Mr. Garberson is going to attempt to secure some type of potential treatment plan that the court would accept, because he has no reason to ever come back to Ohio. Mr. Hill was open to that, so we're going to try to go that route. So that's for approximately a month, and we would waive time during that period, Your Honor.
All right, so we're looking at September the 16th or sometime after that. What's your schedule?
We can do the 16th, Your Honor.
All right, next hearing is going to be September 16. As a pretrial, I'll allow Mr. Garberson to appear at that hearing by teleconference as he's doing today, since he's out of state now.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Marquee Gardner, case number CRB 24399. Marquee Gardner.
There is a it's her mother. I don't know if we want to call her up too as well.
I'm sorry, what did you say, co-defendant?
Yeah, her mother, Your Honor.
What's the name on it?
Her name is Joanne Buris. Jillian Buris.
Who's their attorney?
I believe she's unrepresented, Your Honor.
All right, she's interested. Mr. Smith, I'm glad you're here. Ms. Walters is here.
Yeah, I just found out.
Okay.
Thank you.
Burris. Burris, Jillian Burris.
State of Ohio versus Jillian Burris, case number CRB 24398.
And Ms. Gardner's case is 24399. So Ms. Burris is not represented. Mr. Holt's representing Ms. Gardner.
Your Honor, if I may begin, this is what I've put together. I don't know how completely accurate this is, but this is what I've been told from various places. First of all, this is mother and daughter, and they were living together at the time. I don't know whether they still are or not, and there were two dogs, one of which I believe is a pit bull, and the other is a mixed breed. And Ms. Gardner was away working that day, and Ms. Burris was home, and the dogs got out. They ran out off the property, and there was a young girl that lives in the neighborhood that was attacked, she says, by the pit bull. They were both there. The mother, I don't know if she's here or not, is
Yes, there's somebody raising their hand over.
Miss Garrett.
You want to come out to the prosecutor's table, please?
The child, 12-year-old little girl, is she back in South Carolina?
Yes.
So she lives in South Carolina during the school year. So she's not here now. If they needed a trial, she could be. Now, it's my understanding that there were...
You want me to
where are
sit up
you?
here next to you?
Yeah, just stand up here for me, because I can listen. Were there medical bills?
I didn't take that.
Okay, so there are no medical
I
bills.
kept the dress on myself.
However, Ms. Garrett is very upset that it happened. What we have here, I believe, is a situation where, and Mr. Holt has impressed upon me that Ms. Gardner's dog is the mixed breed, and the little girl says it was a pit bull.
She didn't specify if it was a pit bull. She was upset, so she said that she thought it was a black dog, but it happened so fast.
So the black dog's the other dog. Nonetheless, she was bitten and there were no injuries. But the primary thing, and I think that if Ms. Garrett had her way, that the dogs would be destroyed. But I don't know under the circumstances whether the law would necessarily provide for that. And if so, whether the court would order that. However, we need to make sure that there are, and they may just say, no, none of us are guilty, we want a trial. Or if they wanted to resolve it today, we believe that there is a fence around their yard, and that's the fence, the backyard, and we've asked for pictures. That needs to be used, and I guess it's also, I've been told that the dogs got out the front door, and the fence is in the backyard. We got to make sure that this doesn't happen anymore. We got to make sure that there are provisions for it. All right. So they've got a fence in the backyard. There are provisions in the law for a dangerous dog registration at the county. A dangerous dog is when the dog has bitten somebody. We got 2 dogs here. Don't know which one bit the little girl. There are provisions for, and I believe homeowners insurance has a provision or can that will provide for if your dog bites somebody. And so what we feel like is the best thing we can do, if they're willing to admit this, is to make those part of the order. That they make sure that they keep the dogs contained at all times, that they register the dogs as dangerous dogs with the county, and that they have the appropriate insurance.
They don't know which dog bit.
I'm sorry.
My client is charged with restraint of a dog at M4. She was at work, the yard's fenced in, there's a house. I don't think she can be found guilty of that violation.
That one at trial, it sounds like.
I believe so.
The alternative is that they decide amongst themselves which one is responsible. But it sounds to me like it was the black dog that did the biting maybe, and that's not the pit bull.
Which is in direct counter to the officer's report.
Okay. Well, if we're going to have a trial, we're going to need this child to come back for the trial. Is there a time when she is coming back for a visit, or?
I have her Thanksgiving week. I mean, she comes back once a month, but it's usually on the weekends, so you guys probably already know.
Well, she can come back a little early. We can do it on a Monday or a Friday. Okay, I'm open to suggestions on a day.
If we're going to have a trial, which that's what apparently neither one of them are going to admit that this happened. So we need to have your dog. can't be forever because the law doesn't allow us to go forever.
These are fourth degree misdemeanors, so I'll have to set a pretty
There's already
quick.
some time that's ran as well.
I'm sorry.
There's already some time that's ran as well, Your
Okay, so we
Honor.
got another, who is that?
Was there another witness?
There is, and she lives locally.
Yes.
So, here, I don't know
We
whether.
may not need the child, but
Well, we may not need the child, but we also, if maybe this other child who wasn't attacked would have a better ability to explain what exactly happened so we can pinpoint what happened. I mean, part of the issue we have here is 2 dogs, one of which actually did the biting, I guess. But they're not human beings, it's not like they're accomplices, but they may be more accomplices than human beings are in a situation like that because they incite each other naturally through their just being dogs. But I know that's not a legal standard. If they wanted us to take some time and get a statement from the little girl, the witness, and then come back on a later date and try to sort it out further, we'd be happy to do that too.
I think we need to go to trial, Your Honor. At least my client, I don't think the statute, she can't be held guilty.
okay, well, what's the time, where are we on time? Because we only have 30 days to get this done, and Mr. Holt thinks sometime is already done.
This was filed on 6/25, it was served on 6/28. Then we appeared for the, I have not filed discovery.
There have been time waivers, however.
For the period between the last one. It was a limited time waiver.
See, I've got a time waiver from July 29th to August 16th. It's in the file.
I think time would, under the Ohio computation, from June 29th to that date, Your Honor, the time would have ran. That's nearly a month, isn't it?
The arraignment was July 22nd.
Yeah, I think time starts when she's served. The day after she's served. Since she wasn't present, so she wasn't arrested or cited. So the date, I believe my position as a high law would say that the first day that counts towards the time computation would be 6/29, since she was served on 6/28.
Well, there's no time to set it for trial then. If
Well,
that's correct, and I don't know that it is.
I don't know that that's correct. And we would request then a motion to be filed so we can respond to it.
They don't have to file a motion. I mean,
To
as far
argue
as the
that-
time frame?
Yeah, because our response would be that there've been.
I mean, the court, they don't have to file a motion. The time runs when it runs, so they don't have to file a motion to make the time run.
But here, there's been a time waiver on the record, so we should have the
But it's
opportunity.
for a specific time frame.
Exactly. So then, I would think we would have time to respond to what time has been told towards the speedy trial.
Well, you can do it today. I mean, I'll be here all day. I'll just make you guys stay here until you figure out what the date is. Because I don't think we can do that. I mean, if I say, okay, we're going to take some time to figure that out, that time runs against you too, because they're not waiting then. So, I'll put this aside. You can both look at it, and when you get a chance, we'll come back, and if you can't agree, then I'll have to you can sit there while I go do some research and figure out when the time actually runs. So, but I think that's the way it's got to be done. I mean, the Court of Appeals, it's the Star Wars, Mr. Starr and his office. I mean, even if he agrees to a date, it doesn't matter. You can agree to a date. If it's outside the time frame, it's still done. Okay. So go do some research. I'm going to be here working away. If you can't figure it out, I'll do the research when I get time to. It may be this afternoon. Of course, this case will be recalled later in the docket.
Here's on Garberson. So I need the court's files on those. You guys know. Well, no, it's-
State of Ohio recalls Wendy Aldridge, case number CRB 24511.
Okay, Ms. Aldridge, you were correct. She had a negative screen. Sometimes people tell me they're not test negative. A lot of times they say they're not test negative, but they don't.
I understand.
Anything else you want to tell me before I
I've
send you?
just been going through a lot of just emotional stuff. After separation, my son won't talk to me. Just life, just sappy life, I guess. And I don't know. I have no explanation. Like I said, I've got people, I've cleaned their house every week for 31 years. I'm a trustworthy person, and my livelihood depends on this. And I made a stupid mistake, and I'm sorry.
Okay, well, thank you for your statement. One thing about the law now, you can have this expunged after a certain time frame if you don't have any further offenses. If you
I've never.
want to get it taken off your record, you can, but you have to be off probation and not have any further offenses. You can talk to a lawyer about it. Then it's not self-executing. You have to come back to court and ask for it to be expunged. I don't know if that would be important to you, but that is something that you can do.
It is very important.
Okay.
My name's all I got.
I understand. I'll impose a $50 fine, or you can pay the court costs, 10 days in jail, all suspended, on the conditions you do 5 days of community service, and here's the worst part, more you stay out of Walmarts. I don't know how they stay open. I've ordered thousands of people not to go to Walmarts and they're still open.
That don't hurt my feelings. Does that mean all Walmarts?
Yes, ma'am.
Okay, I can do that. Can I start the community service next week, like Monday?
Yeah, you can do it on your days off. We have community service 6 days a week here at the court. So work around your work schedule. I want you to see Mr. Major, who's the probation officer here. His office to the left as you leave the courtroom. Go over there, talk to him, get your paperwork, get your stuff done. You'll have a review hearing on this. I'm giving you till February to get all this done. If you get it done, you don't have to come back to court even. It's just a hearing to make sure you do what you're supposed to.
I
So if
definitely
you get it
will.
done, you don't have to come back. If you haven't done it, you gotta show up for the hearing. If you don't show up for the hearing, then you get a warrant for not showing up.
You don't have to worry about that.
Okay, I'm not gonna worry about it. I've got other things to worry about. I'm not gonna worry about that.
No, I'm sorry.
Well, I believe you are. So we all make mistakes. You made one. Just go on, have a good life, and don't make any more mistakes. Don't make this mistake anyway. A lot of people keep making the same mistake over and over. Don't make this mistake.
Who do I talk to?
Do not shoplift people. Walmart will catch you. If you're gonna shoplift, don't do it there unless you want to get caught. Yeah, February the 10th, that's right. That's right, February 10th. Is your next review, is your review. So go see Mr. Major.
Who do I talk to and pay?
Out in the lobby to the left.
Okay.
That's the probation office. Go talk to Mr. Major.
Okay, thank you.
You're welcome.
Gardner, ready for the Lawrence County Jail. State of Ohio versus Jonathan S. Black at the Lawrence County Jail, case number PRD 192281. From Jaren Edington is on there.
Okay, sir, you're Jonathan Black. It's alleged that you failed to appear for a hearing January 28th of 2020 on a driving under suspension case. You got a warrant because of it, and it looks like that's why you're in jail. Do you understand that? You have a right to remain silent, you don't have to say anything, you have a right to have an attorney, to have one appointed, to have bond, to make the state prove this charge against you beyond a reasonable doubt. Do you understand those things?
Yes.
The charge is that on June 25th of 2019, in Fayette Township, at 9:50 p.m., you were driving a vehicle while you were under suspension of your driving privileges. It's a first-degree misdemeanor, maximum penalty 6 months in jail, $1,000 fine. How do you plead to this charge?
Guilty.
That means you're admitting it's true. Do you understand that?
Yes.
Okay, the officer says subject was stopped for a stop sign violation, checked his license, and they were suspended. How long you been in jail now?
3 days.
Okay. How'd you get picked up?
I was at a funeral at a house from your own, and I went to meet somebody at Speedway in Buckerville, and they pulled us over.
And found you had a warrant?
Yeah.
Okay. Well, when you don't come to court when you're supposed to, bad stuff happens. Now, it may take a while. It took 4 years for it to happen, but it does happen. So, anything you want to tell me about this?
I apologize, sir.
Okay, but you learned your lesson. It's better to face up to it and come to court when you're supposed to. You probably wouldn't have got any jail time out of this.
Right.
Do you have a license now?
Yes.
Okay. I'll take your word for it since you got jail time anyway. Yeah, it looks like back then when this happened, you were on a motorcycle, right, in Kawasaki?
Yes.
Okay, I'm going to sentence you to 10 days in jail. I'll suspend 7, give you credit for 3 days you've already served. I'm going to order that you do 5 days of community service. We have a community service program here at the court that you can do. I'm going to have to make it a $200 fine, so you're getting about twice what it would have been if you would have come to court back when you're supposed to. Otherwise, if I don't hit you a little harder than I would have back in 2020, nobody's going to come. I have a hard enough time getting people to come to court now. If they know, well, I can blow this off and I'll get the same thing 4 years from now. Everybody's going to take that deal, right?
Right.
So, you got a $200 fine, court costs. You got 3 days in jail out of it, 5 days community service. So that's more community service and you wouldn't have gotten any jail time. 2 years of level 5 probation. I'm going to set your review hearing for February the 10th of next year at 9 o'clock. So I don't want you to go back to jail. I'm assuming you don't want to go back to jail, right?
Right.
But you got to do what I'm telling you. You got 5 days community service and fines and court costs and a review hearing. So how could you go back to jail on this?
I couldn't.
No, you can go back to jail. Wrong answer. So I thought you learned, but you haven't learned enough yet. How can you go back to jail? By not doing what you're ordered to do. If you blow this off, if you get out, and I have people do this, like they're all sorry about going to jail and all that, they'll never, and then they walk out of the jail, it's just like they were never there. Blow it off, don't pay their fines, don't do their community service, don't come to their review hearing, and guess what? They get a warrant. Then they act surprised when they wind up wearing an orange jumpsuit again. You gotta pay attention, man. This is serious business. It's not like voluntary. Like, I don't know, maybe your mom said, take out the trash, and it's like, I don't want to do it, Mom, and nothing happened. Well, this isn't like that. Something's gonna happen if you don't do this. I don't want it to happen. I don't want you to go to jail. I want you to do what you're supposed to do. But if you don't do it, what can I do? I gotta issue a warrant for you. You gotta go back to jail. You understand?
Yes.
Okay, so it's up to you. I'm telling you the date. We're not gonna call you up and say, Jonathan, remember your hearing date? Remember, like, you gotta get out of bed and go do community service today, Jonathan. No, we're not doing that. We're gonna treat you like an adult, like a man. You're a real grown man, right?
Yes, sir.
So get this done. If you don't remember when you're supposed to do it, it's pretty easy. The court's here every day. You can call, find out what you gotta do, or go online. I'm sure you've got a smartphone. Everybody does. You can go on the website and put your name in, and it'll show you what you gotta do and when your next hearing date is. So there's no excuses. Okay, February the 10th is your review hearing. Get your community service, pay your fines and costs. Otherwise, show up on February 10th, explain why you didn't do it. Any questions?
Yes, sir.
Okay, that's it. You'll get out today. Unless you've got a holder from another court.
State of Ohio versus Jaren Edington, case number TRC 23-1190, and Angela Hamlet is on deck.
All right, you're Jaren Edington.
Yes, sir.
Mr. Edington, it's alleged that you missed a review hearing on April the 19th of 2024, and it was on an OVI case. And it looks like you got picked up on the warrant. Do you understand the allegation? Do you understand why you're in jail?
Yeah.
Do you admit that you missed your hearing?
Yeah.
Have you got a good excuse for missing your hearing?
I mean, no, but there really is one.
Yeah, you were overseas in the military fighting the war. You were in the hospital continuously since then. Something like that. I don't think you have one of those, do you?
Well, one of those, but I'll try to make money where I can pay my fines and stuff.
No, that's not a good excuse.
I don't know.
In fact, somebody is paid on your fines. Suspect it was either your grandparents or your parents probably paid on it.
Yeah.
Not you, right?
Yeah.
Okay. Well, you're on probation, so I'm going to order that you do a urine screen today. Let's see what that shows. So to go do a urine screen, I'll get the results, come back, and we'll address whatever that shows. Hopefully nothing, but if it does, it's something I need to address. So go do a urine screen.
State of Ohio versus Angela Hamlet, case number CRA 24509, and Melissa Rand is on deck.
Ma'am, are you Angela Hamlet?
Yes, sir.
Ms. Hamlet, it's alleged that there's a warrant for your arrest out of Boyd County Circuit Court.
Yes, I said it was pro PB for not reporting.
So the way this works, and let me make sure you understand your rights. You have the right to remain silent. You don't have to say anything. It's all on the record here. So if you admit something, it could be used against you. You have a right to have an attorney, to have one appointed, to have, well, they're asking for no bond from Boyd County. You have a right to make either the state of Ohio, Commonwealth of Kentucky, somebody's got to prove this stuff beyond a reasonable doubt. okay?
Okay.
Here's the allegation, that there's a warrant for you from Boyd County Circuit Court, so that's Kentucky. And they're saying probation violation on a bunch of charges. Possession of controlled substance, methamphetamine, heroin, marijuana, drug paraphernalia, contempt of court for, I assume that's failure to appear, and they're asking for no bond. So you have a right to an extradition hearing, that's called. That's a hearing to decide, is there a good reason to send you to Boyd County Circuit Court? And you can have a hearing on that, you can have a lawyer represent you, but that would be the issue. The hearing is not going to be about whether you did or didn't do these things. It's going to be about, is there a good basis to send you to that jurisdiction?
Yes, I go to taking basis.
So you can ask for an extradition hearing and we'll have it, or you can waive extradition. If you waive extradition, you're saying, not necessarily saying you did what they allege, but you're saying, I agree to go over there and face these charges.
Yes.
So how do you want to proceed? Do you want to have a hearing here, or do you want to go to Kentucky and face the charges?
I want to go to Kentucky.
So you want to waive your extradition hearing?
Yes, sir.
Okay. I'm going to honor their request, so no bond. So I'm not going to, if they had set a bond and you could post it, I'd like you to go turn yourself in, but that's not going to happen. So you're going to be in the jail till pick you up. Usually Boyd County, they're right across the river, it's not a problem. 2 or 3 days, usually they come pick somebody up. So I'm going to give them a week. So if the jailer's listening in, go ahead and tell Boyd County she's ready and free to pick up. And I'll give them until next Friday, which is the 23rd at 8 a.m. So if you're still in our jail next Friday morning, I'm going to see you just like this Friday morning on teleconference and figure out what went wrong. Because that meant something went wrong in the communication. I just don't want you lost in the back of the jail and nobody knows where you are. So I'm going to keep track of it.
Thank you.
But you should be in Boyd County well before then. So we're going to send a paper down to the jail for you to sign that just says, I don't want an extradition hearing. I agree to go to Kentucky.
Okay.
So you'll sign that, send it back to the court, and it'll be in your file. Do you have any questions of me, ma'am?
No, sir.
Okay, that's all.
Thank you very much.
You're welcome.
State of Ohio versus Melissa LeGrand, case number CRA 24513, CRB 24462.
All right, Mr. Morford's the lawyer, and I'm told there's a new charge against her. I don't know if you're aware of that, Mr. Morford.
I'm not, Judge.
We'll give you the charge since she's in custody. The new charge is case number 24513. It's a vandalism charge that August 9th, Union Township, Melissa LeGrand, known cause physical harm to property that was owned or possessed by Teddy Stanley. That's a felony of the 5th degree. Maximum penalty is a year in jail, $2,500 fine. That 24514 is a resisting arrest charge that on August the 4th in Windsor Township, she recklessly, by force, resisted or interfered with the lawful arrest of herself. That's a 2nd degree misdemeanor. Maximum penalty 90 days in jail, $750 fine. 24515 is a breaking and entering charge. That's new. That August 14th, by force, stealth, or deception, in Windsor Township, she trespassed in an unoccupied structure with the purpose to commit a theft offense. And I think that was a church out in Breezy Ridge, I believe, I was told about. So that's a felony file also. So, Mr. Morford, I think you were already appointed previously on July 29th to represent her all.
Yes, sir.
Appoint you to represent her now. She got an OR bond before on July 29th. I think from the state may change their tune on that.
Absolutely, Your Honor, and I wonder, given, I mean, this is kind of a bizarre set of incidents in a row, so we feel like, first of all, if she got out right now, she's liable to do more things, first of all. Second of all, there's got to be some underlying explanation of some sort.
I'm going to suspect substance use.
That's,
I mean, it's rampant in our community already, and I'm going to say that may be a reason someone would do the things that it looks like she's charged with.
and they sometimes lead to mental health issues too.
Correct.
So we believe until we can get to the bottom of it, she needs to be kept in custody. So we're going to ask for cash or surety bond that'll help do that.
I'll set bond at $5,000, cash or surety. So she's been in jail though for a while, so I would be amenable to looking into some sort of treatment for her as a part of her bond with an ankle monitor, though, I think would be appropriate under these circumstances. So, Ms. LeGrand, do you have a medical card?
No, sir.
Have you ever had a medical card?
Yes, sir, I did. One time,
Ohio or where?
Ohio.
When's the last time you had one?
Probably last year.
Okay, so it's been fairly recently.
Yeah.
Have you been to inpatient treatment before?
Not recently, years ago.
Where'd you go before?
I went to prison to Marysville, and then I went to the Alice house for a year.
After you left prison?
Yeah, yes. Yeah, I was in trouble free for 4 years, and then I came across a rock and a hard place, and I don't have nowhere to live. And
well, inpatient treatment could solve that problem too. Are you interested in going to treatment?
Yes, sir. I'm drug free, but I'm interested.
Well, I can't send you to treatment if you're drug free. Would you take a urine screen today?
Yes, sir, I will.
Mr. Morford, what did say you?
That would be good, Judge. I think that substance use might be a problem. And there are allegations in the first case, Judge, that caused me to have a little bit of concern for her mental health.
Okay. Well, let's start this process this way. Let's have you do a urine screen and see what that shows.
All right, that's good.
Okay, go do the urine screen. I'll get the results back, and we'll have you back on camera after I get the results.
All right, yes, sir. Thank you very much.
You're welcome.
Thank you, Judge.
You're welcome.
State of Ohio versus Toby Pack, case number CRA 24326, and Logan Wright is on deck.
All right, Mr. Pack, and Mr. Morford, you're his attorney.
Yes, sir.
It's set for a pretrial today.
I thought it was an extradition.
There was an extradition matter, I believe, Judge.
Yes. We're waiting on a governor's warrant from Boyd County, so he's been in jail for quite a while, so since June. I have some emails from Melissa Lambert, Administrative Assistant to the Boyd County Commonwealth's Attorney, Captansburg. Did someone try to contact her and see, get an update on their efforts? He's got, looks like his most serious charge was a fleeing or eluding police. But he has, they asked that he be set a 20,000 cash or surety bond, which I did set, but he can't post apparently. Okay, so he's been in since May 29th. Okay, all right. Jasmine's gonna call, see what she can find out. So, sir, we'll have you back up after we get some word from Boyd County.
Thank you, Your Honor.
You are.
State of Ohio versus Logan T. Wright, case number CRB 24512 A and B, and Harry Roode is on deck.
Sir, are you Logan Wright? Yes, sir. All right, Mr. Wright, Judge Capper at the Municipal Court in Chesapeake. This is your arraignment hearing. You have the right to remain silent. You don't have to say anything. If you do make statements, it's being recorded so it can be used against you. If you admit something about your case, you have a right to have an attorney, to have one appointed if you can't afford one, to have bond, and to make the state prove these charges beyond a reasonable doubt. Do you understand those things?
Yes, sir.
You're charged with an assault charge and a disorderly conduct charge. The assault charge is case number 512A. It alleges that on August the 14th in Perry Township, you not only caused or tried to cause physical harm to Brianna Fugate. That's a first-degree misdemeanor, maximum penalty 6 months in jail, $1,000 fine. You're also, on that same day, charged with disorderly conduct. The allegation is you were voluntarily intoxicated in a public place in the presence of 2 or more other people and engaging in conduct that was likely to be offensive to them or cause them inconvenience, annoyance, or alarm. That's a minor misdemeanor. Maximum penalty is $150 fine. Do you understand these 2 charges?
Yes, sir.
How do you wish to plead to these charges?
Well, the disorderly conduct, I would have tricked him, to be honest with that. The other thing,
Okay, so not guilty to the assault and guilt? Is that what you want to plead? That's the
Yes, sir.
Okay. Well, that's the jailable offense. The other one's not, in the scheme of things, not that serious. So do you want a lawyer appointed?
Yes, sir.
Do you have a job?
No, sir, I was just in treatment in TCC.
Did this happen there?
No, sir, I know leaving and get drunk.
Okay. Mr. Smith, I'll appoint you.
Your Honor, Mr. Rife, I believe we just had him at Ironton Municipal Court yesterday.
We did. There's a bond revocation. There's a hold on him out of Ironton Municipal Court.
Okay,
For
so he's
leaving
got a holder
TCC.
for-
Yes, sir. So I think they set that for this Thursday when Judge Waldo's back. Either this Thursday or the next.
What's the state's position on bond for this case?
Well, we'd ask for $1,000 cash or surety bond.
All right, I'll set 1,000 cash or surety.
And Judge, I am not here next Friday. I'm in trial, but the 26th I'm here. Monday I'm here.
Are you representing him?
I am. In Ironton. I have been appointed in Ironton, yes.
Excuse me, sir.
Yes, sir.
I have a question. You know what happened if I just go ahead and plead out to that?
Well, I do not, because I don't know what the charges are. If you want to talk to your lawyer, then
Yeah, I would advise you not to, Logan. You've got a hold, you're not going anywhere anyway because John Kincaid put a hold on you. I would advise you to maintain your not guilty plea today so I can talk to you. And we'll set this as soon as we can. It's not like If you pled today, you're going to walk out of there today, so do not enter a plea today, let me talk to you.
I'll set your next hearing for August 26th.
I can do that, Judge, yes.
August 26th will be the next hearing, will be a pretrial at 10 o'clock.
Thank you.
You're welcome.
State of Ohio versus Gary M. Roode, case number CRB 21392A and B, TRD 22805A and B, and Hunter Tooley was on deck.
Gary Roode is Mr. Morford's case. Celeste, he has a sentencing hearing on August 12th, so. He had a bond up with Mr. Sowers, I think.
I believe that's my recollection, Judge. I do know he wasn't here for his sentencing.
Okay, and I have, let me send, I'm sending a text to council. That I received from Mr. Sowers. But ask you to review that and then decide how some indication he needs treatment, so I don't know if he wants to avail himself of that or what. I'll see.
Shall I call him, Judge?
Yes. I'll let Mr. Morford talk to Mr. Roode, and then we'll recall him after that.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Hunter E. Tooley, case number CRB 24385 A and B, CRB 24329, CRA 24328, CRB 24292, CRB 23147.
Mr. Tooley had missed a pretrial on August the 5th. He got picked up on a warrant, and he's in back in custody. And
Judge, was
this is Mr. Morford's case also.
he was in treatment, wasn't he,
Last
Judge?
treatment, I believe, if I recall.
That's what I thought happened about the time he didn't appear.
Yes. You want to talk to him also?
Yes.
All right, your lawyer's going to call down, talk to you, Mr. Tooley, then we'll recall it after that happens. Okay, we're going to come back here for some hearings. We've got some recalls to do from the jail, but we're not ready for those yet.
State of Ohio versus Michael Hayes Jr., case number CRB 24438 A and B, Mr. Holt's case.
Set for pretrial today. Got a text about Toby Pack, since Mr. Bashir didn't get the job he thought he might get. He did get the warrant down and sent it to our governor. We're waiting on our governor to do something now. Mr. Holt like that.
Yeah, I do. Very much so.
He would have been a good.
He might be
Rhinos don't do anything.
That's
He might be hiding out from an indictment himself, Mr. Houston.
Which one?
For the First Energy, Houston may get indicted for First Energy. Some handwritten notes they discovered.
So what are we doing with Mr. Hayes?
Your Honor, we've spoken with the victim of this matter, and she is not interested in any restitution, first of all. She also has pretty much left how we handle this case up to our discretion. She obviously doesn't want any more incidents like this, but Mr. Holt has given me some information about medical conditions that Mr. Hayes has that might have contributed to not really understanding the import of his actions on that particular occasion. It might have been a medical situation. So what we would like to do is, under the circumstances, I think we're willing, because he gave me some medical records that show some issues that can contribute to this kind of behavior. We just want to make sure that we don't have another issue of this nature, and what we'd like to do is just continue this out for about 90 days, and if there aren't any further problems, we'd be okay with dismissing it with costs at that time.
We're fine with that, Your Honor.
Okay.
Thank you.
Mid-November, what's your schedule?
Would the 15th work, Your Honor?
Yes. Next hearing's November 15th.
He can pay the court costs today if the court will allow him to.
Yes. So, case will be dismissed then, no appearance required if there's no further problems.
If there's no more problem, you have to show up.
And cost will take.
Thank you, Your Honor.
You're welcome.
And we need to talk it over too.
Yes. You're good to go. You ain't gonna pay those, okay?
Yes.
You ought to show up, okay?
Okay. It won't happen again. Thank you, Your Honor.
Thank you.
What's the date? JT?
State of Ohio versus Marquee Gardner on recall, case number CRB 24399, and Jillian E. Burris on CRB 24398.
All right, so these are on recall. We're go ahead and both sides do a little research on the time issues. So we got an agreement on that, or not?
I can tell the court what happened. So the summons for Ms. Gardner was served on June the 28th.
I agree.
The arraignment was set for July the 22nd. So, 3 weeks anyway on an M4 kind of puts us behind the 8 ball before the prosecutor's office had anything to do with it, number one. So that's 24 days that's elapsed out of the 45. Then from there was a pretrial set the next week, which adds another 7 days. That makes it 31 days. Then there was a continuance time waiver to today, so there's 31 days that have elapsed. We got 14 days to try the case.
Do you agree with that?
Yes, Your Honor.
Okay. Well, we got 14 days. I'm probably going to be here several times during those 14 days. Would you like it set on the 14th day, or you want it set before then? That would be the 30th.
I would rather do it on the 26th, Your Honor. I have depositions that are absolutely cannot be moved.
Okay, both of them. The 26th, is that within the time? You don't want to get sabotaged.
Yeah, that's 10 days from today.
Okay.
All right, so I've set it for August 26th at noon. And I could be convinced, I'm not sure we've ever done that before, but if she wanted to appear by teleconference, I might allow that.
That's a
To testify
solution.
that way.
Okay, we'll try to arrange that.
I don't know of any reason it couldn't happen. That way. All right. August 26th, noon for trial.
Yeah. I don't really want to talk to her. Yes, yes.
State of Ohio versus Nicholas R. Adams, case number TRD 20-1480.
Nicholas Adams.
Can you do that?
All right, Mr. Adams, looks like you did make a payment recently on your bonds and your costs. You still have community service to do?
I've paid off the fine.
Okay. I don't know. You think you have paid off the
Yes, sir, I paid it off on online this morning.
This morning? Okay, well, I wouldn't get that yet.
Yeah.
You still have 2 days community service to do, right?
Yes, sir.
Okay, I'll cancel the bond forfeiture hearing, and Mr. Sowers had texted me this morning, he thought you were coming in today. I guess he had called you.
Yes, sir.
So
I spoke to him.
I'll let him know you're here, and I'll cancel the warrant. Bond forfeiture hearing's canceled. I'll set your next hearing, since you paid everything, you just need to get the community service done. I'll give you till September 30th.
You want it as a sentencing or a review?
It'll be a sentencing, because he's got a bond up.
Thank you.
Get it done, you don't have to appear.
Yes, sir.
September 30th, 10 o'clock for sentencing to your next hearing.
Yes, sir.
Okay, that's all.
Thank you.
State of Ohio versus Heather Fowler, case number TRD 24997. It's also in the right.
Heather Fowler. Heather Fowler.
Yes, sir.
Okay. And I believe Mr. Morford's your lawyer, right?
Yes, sir.
He may be tied up, he was calling the jail. Have you talked to him today?
I have not.
Okay, just have a seat, we'll have you talk with him, we'll call it after that's happened.
Yes, sir. Thank you.
The bail can give him your file.
Okay.
State of Ohio versus Kelly Bishop, case number CRB 24375.
Your Honor, Ms. Bishop left treatment. I'll let
So after her ankle monitor was removed, she was due to continue to Phoenix Rising the next day. And that evening, we took them out for an outside meeting and she ran. And I have a letter for you, but I'll have to send it to you via email.
Okay. And she has felony.
And she never reported to Phoenix Rising and
She does have a felony, Your Honor. She also pled guilty to the theft offense previously, and sentencing is pending.
How do you want to proceed on it then?
We'd ask for a warrant from this court.
Okay, it'll be bench warrants issued from this court for her leaving treatment and not appearing for a pretrial.
You know what, she has not pled to the theft, but we still want the...
Want to keep it here?
Yes, please.
All right, warrants issued from this court.
Yes, Your Honor.
thank you, Your Honor.
State of Ohio versus Derek A. Chapman, case number TRC 241275, A and B.
And Mr. Chapman said ODP outpatient.
Well, Your Honor, they recommended that he come inpatient, so he is now at the recovery center.
Okay, so you did, and you complied.
Yes.
Great.
expected to graduate 1st of September.
Yes, Your Honor, this is an OVI. I think we can resolve that at that point and then go from there. So I just asked for this be reset for close to the 2nd.
Mr. Hill?
Typically, we want to resolve the OVI independent of whether the treatment's going on or not, at least with the plea. And then we can discuss disposition if he's successful in treatment. Otherwise, we'll go ahead and just proceed with the OVI and set it for trial.
We don't need to set for trial, Your Honor. We're going to resolve the OVI.
So you want to change the plea today to guilty?
Yeah, we'll do that. Plead guilty to the OVI, Your Honor. Just ask to be set for sentencing. Right after the 2nd or right before the 2nd?
That was, looks like the only charge.
It was.
Well, let's see. Make sure of that.
It's only charged on the docket.
Looks like it. Is there a B?
No, there's
There
not.
were a B on here.
Oh.
I don't see a B.
But come through like that, or is no big?
Okay.
Now, there's not.
All right, and we'll make sure, Mr. Chapman, this is what you want to do? You want to change your plea to guilty as to the OVI charge?
Yes.
Okay, I'm going to delay sentencing while you continue your treatment. The better you do in treatment, the better I'll do on your sentencing. So there's an added incentive for you. Let's set the 9th. I think I already set a case for you on the 9th, Mr. Chapman.
Yeah. Oh, that's be fine, Your Honor.
September 9th for sentencing. You'll be finished with inpatient. And there's going to be a plan made for follow-up after inpatient.
Yes.
We'll talk about that then. September 9th for now be sentencing.
All right, do good.
Thank you, Your Honor.
State of Ohio versus E&T Geringer, case number TRD 241314, A, B, and C.
How you doing? Thank you. Did you get your Kentucky license?
I'm still working.
Correct.
I have an appointment set for next week.
Next week. Your Honor, we've been working on the Kentucky issue. He just informed me that he has an appointment set next week.
Yes, sir.
To get that taken care of. So if we could set this in a couple of weeks, we'll have it resolved then.
Mr. Field.
What is the Kentucky issue?
You can explain it better.
I'd received a DUI in Carter County, and I went to turn myself in, but the went to return myself in 3 times on 3 separate occasions, and they had not filed my paperwork for me to turn myself into the Carter County Jail, and I had called down to the Carter County clerk's office after those 3 separate times to see, what was going on with my paperwork, why hadn't it been turned in, why can't I turn myself in to go do my 6 days in jail, and I guess they just couldn't give me an answer.
When do you think you can get that resolved, sir?
I have an appointment set for next week on Wednesday.
So what are the charges here, Your Honor? Just
Driving under suspension.
Yes, sir.
And,
Well, one of them, though, is driving under an OBI or alcohol-related suspension. So that's a mandatory jail. Requiring mandatory jail.
yeah, and the distracted driving.
So we're not opposed to a continuance, letting him straighten all that out. We'll need a time waiver.
Yeah, we'll wait time.
So it sounds like he's going to serve 6 days and maybe a month out before we come back.
Yeah.
September 16th.
Yes, that'll work. September 16th.
September 16th for pre-trial at 10 o'clock.
Thank you so much.
Thank you, Judge. You're welcome.
State of Ohio versus Staniel James, case number CRB 23317.
Mr. Strack's case.
Oh, yeah, he's here. He's at Bethesda, Your Honor.
Bethesda.
Your Honor, he's fully compliant. I can't not get the progress report to fax over for some reason.
Okay. End of September?
Yeah.
So next meeting, September 30th?
Yeah, that'll work.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Alexander Jones, case number CRB 24383. Alexander Jones.
Hey, Your Honor, there is, I'll let him explain as to what's going on with this. Is it what you told me? Yes. Okay.
Your Honor, as it states in the letter, Mr. Jones is non-compliant. He had reported to staff he was out of town working. We made numerous attempts to contact him. He's not showing up to court. He's not showing up for services.
He does work out of town, Your Honor, but I know that you mentioned that he had to appear today, so the last 2 times he wasn't here because he claimed he was out of town. But there's been some personal issues, I guess.
Yes.
And he is...
His girlfriend says she has no way of getting a hold of him. His mom says she has no way of getting a hold of him.
So...
My hands are kind of tied.
Okay. There'll be a warrant issued for failure to appear, and he has a bond, so that's my notes. Let's see. Yes. I will notify Mr. Sowers.
Okay.
Thank you, Your Honor.
Thank you, Your Honor.
You should tell him, Mr. Jones, it'd best be that you get in here before Mr. Sowers gets hold of it. Set a bond forfeiture hearing for Mr. Jones. September 23rd.
September 23rd, yes, Your Honor. Yeah.
State of Ohio versus Tony Walters, case number CRA 23466, CRA 23467 A and D, CRA 2354.
Mr. Smith's case.
Wow.
There's some property. Okay. These mine? This is copies for... She's still in treatment? Are you still in treatment? Done in treatment?
I know, I'll watch it.
Yeah.
She cleared a while ago. She cleared it. It was just, we're trying to get this stuff cleared.
Well, thank you for continuing to do that. Keep at it.
Your Honor, she's making significant progress on cleaning up the property. I just showed new pictures to Mr. Hill. I'd say maybe another 30 days or so to see how it's going.
Okay. So state satisfied the letter, keep working at it?
Yes, and actually, she pled guilty to littering previously, was never
Okay.
sentenced on it, and we've got these two other charges, of aggravated menacing and obstructing, that are still pending, but we wanted her to get through treatment and get this other stuff straightened out, and she's doing pretty good at it.
Now, at one point, she was at Cardinal.
I think she's completed.
I think there's a certificate of completion.
She did, I believe she completed that last fall.
Yeah, y'all got your papers.
10/27/23. But then she had missed a hearing date too for a while, back in April. Okay, so we'll just reschedule. Let's go into 1st of October, give her a chance to get things completed. October 4th?
That's fine, Your Honor.
October 4th will be a pretrial, will be the next hearing. So, actually, these are, one case is still pending, the other is resolved, so we'll just treat it as a pretrial and review, so both will be on the pretrial docket.
And I've advised her if she gets it completely cleaned up, that we'll probably just resolve it that day. All right, thank you, Your Honor.
State of Ohio versus Francisco Solomon, case number TRC 24-1412, A, B, C, and D.
Morning, Your Honor.
Good morning. This is set for a pretrial day, and Mr. Trujillo has entered interference.
I've also filed a motion to suppress in the matter, Your Honor. It's my understanding the state would like to try that. And it was just filed this morning, so the...
Okay.
Not
I don't
there.
think I have that in file yet. Do we want to pre-trial it first, or we set it for a hearing?
Today serves as a pretrial. Mr. Hill had been provided a copy prior thereto, so he has reviewed it. It's my understanding, and it's my understanding we need to have a hearing.
Shield?
Yes, Your Honor, Mr. Trujillo gave me a copy of the motion this week, and I looked everything over and decided we should go through with the motion.
All right, let me throw out some dates, and you can tell me what works. The 6th of September would work.
If I may, Your Honor, would it be possible to have it in October? I have a murder trial in mid-September, and it's going to be preclusive.
Okay.
And the filing of this motion does toll time, so it removes that.
Anytime, any of the dates in October are okay. We've got a holiday on the 14th, so work will be on the 15th.
October 15th is fine for my schedule, Your Honor.
That's a Tuesday.
Yes, Your Honor.
Mr. Hill?
October 15th?
Yeah, that's a Tuesday.
Okay, I guess, what's the Monday? Columbus Day?
Columbus Day.
That's fine. The only thing, we'll have to contact there's 2 troopers involved, make sure that they're available.
October 15th, I'll set the motion hearing at noon.
Your Honor, we'll also need a Spanish interpreter. I have not had to deal with that before. How do I go about formally requesting that?
Well, lately, the Supreme Court's been providing them, but they're by phone, so that's not, I mean, it's okay for a small hearing, but for a trial, I don't think that would work very well. Now, my suggestion would be, and it's up to you, if you want to insist on one that is approved by the Supreme Court, we'll do that. I don't know if they'll send somebody down or how that would work. But Dave Lucas teaches Spanish at the local branch, and he's done it for us, and it seems like everybody's been satisfied. So if you want to talk to him, and he'll come in person.
Tienes un derecho a tener un trámite, pero los funcionarios del Estado tienen que tener un trámite oficial, pero los funcionarios no tenemos un trámite oficial, pero hay un maestro de la escuela de español acá y él puede traducir. Si no tienes un problema, pues algo.
I don't think we would have a problem with a Spanish teacher, Your Honor, if available. And forgive me again, I've not done, is this something my client will have to fund? Is that state funded?
No, the court pays for it.
Okay.
You want to write down your cell, I'm going to put us all 3-4 on a text message to him and see what his availability is. And this would actually, it's not a trial, be the motion hearing.
Yes, sir.
But it will be pretty involved. Ten 15. Should set aside a couple hours anyway, probably.
I believe so, Your Honor. I will have to get pretty in-depth into the NHTSA manual on this one. But I won't have any other witnesses other than the troopers, so it's...
Okay, so I'm about to send the text out and just ask him to respond here. And then if he's not available, we've got plenty of time to find another way to go.
And Portsmouth does have an employee that does act as at least a friend of the court in a lot of these instances. I'm not sure if she's actually received the final certification, but I might be able to reach out to her and see if she would be available as well.
I think as long as you're and your client are satisfied, Mr. Hill and I will be okay.
Yes, Your Honor.
Okay, so unless something else comes up and we need to talk about it, which we could do without a formal hearing by telephone conference, otherwise October 15th at noon for the motion hearing.
Yes, Your Honor. Thank you.
You're welcome.
May we be excused?
Yes, yes. Well, stop him, because I can't read his writing. I don't know if that's an 8 or not.
I'll have them give this to Dorothy so she can follow that.
Okay, I didn't get, I sent a text about putting, is that 939 or 839?
9, Your Honor.
Okay.
93925.
I got it.
Should have gone to med school, Your Honor.
Okay.
Thank you.
You're welcome.
State of Ohio versus Tanya Prosser, case number CRB 24369. Tanya Prosser.
Mr. Smith's case, and she had going to a treatment facility, contemplations?
I thought in Cerrito, if that's the one that was in Cerrito, yes. But I have not had any contact from her or them. The fellow who's the alleged victim in this charge received charges himself here earlier this month, Mr. Stratton's his lawyer. And I don't know if it's the same as my client's the victim on that one, or if it's a different person.
Christopher McBride?
Yes, he's the alleged victim in the case against Tanya Prosser, and I saw, in fact, Mr. Hill's the one who made me aware that he's also been charged, but I don't know if it's a different alleged victim or it's my client. But I have had no contact since, I believe, the 28th of June, Your Honor. She was going to go to treatment and at least have an evaluation, contemplations about some mental health.
He was here this morning for arraignment, or?
Was he? I know he was, this is a pretrial on the 23rd on, yes, Mr. Hill saw it on the docket and told me about it, but I don't know the facts of it.
We can find
His
out.
lawyer's right over here.
Yeah.
Mr. Stratton's his lawyer, right?
Put him on the hospital, yes.
I had her down
Mr. McBride.
for the 23rd also, not here.
And that's what I was wondering, maybe they got put on the same date? I don't know.
They did,
Okay.
because I told her that it says 8:23 at 10 o'clock.
I think we moved his the same day.
You want to just continue? it
If we
to-
could, Judge, that would make sense. It might be a crossfire. Yes, that would make sense. And I will get a hold of her and make sure we have a report from contemplations. I'm not
Treated as a continuous request.
Yes, and I'll sign a waiver, Judge, of time.
Yeah.
And she said she was charged. I think we moved hers the same day as his.
So we'll come back on 8/23.
State of Ohio versus Trevor Dement, case number CRB 24344, CRB 23514, CRB 23380, CRB 21167. Trevor Dement.
Yes, here.
Where is the treatment? Where? Cardinal. Are they here?
Yeah.
Cardinal. You have a report? Okay. Have you received one by email by any chance?
I have not.
don't believe so, but they're advising me, she advised me, Your Honor, that he's getting ready to complete inpatient, go to outpatient. They wanted to send him to OVP. He's been at OVP for a while. I think that he needs a change from OVP. So I told him anywhere but OVP would be acceptable.
Okay.
I believe I'm going a new in Chesapeake, the behavioral health,
Okay, do you know when you complete?
Monday.
So, I'm not sure what kind of a time frame you'd want to look at to come back on this. If you start in a new place on Monday, maybe give it 2 or 3 weeks and see if he gets established there. And
Well, I'm not sure a new does substance use to it.
Yeah.
I'm not sure, Your Honor. I don't know much about them.
They, it's the mental health and substance
I knew they
abuse.
do mental health, I didn't know if they did substance use.
Yeah.
also.
Yeah, they had the MAP program.
Is that what you're going to be doing?
Yeah.
Okay. When did you want to come back?
well, I mean, I'd leave it to your discretion, but I think a couple of weeks would probably be good. Since he's going to be established in a new place, see where he is, and then reassess when to come back again.
September 13th?
I'm available, Your Honor. So write that down, September 13th. You got that right? Yeah, I think that's good. That's all. All right.
All right, thanks.
State of Ohio versus Amanda Hicks, case number TRD 12-1804, CRB 12-456, CRB 08-162.
And it's Mr. Morfer's case. And how did your hearing go in Carroll County? Haley, right? Did you go to hearing with Haley?
Yes, yes. Everything's going pretty good, but she needs to be back. We're waiting on Project Hope to hopefully let her back in. But at least she's willing, you know, so.
Okay. And, yeah, I contacted the director there and gave her a recommendation.
Yeah.
So I know she needs to keep in touch with them and keep showing interest, and I think that will help her
Okay.
get in.
Sure.
That's what they told me, so. And how are you doing?
I'm doing good. I'm doing really good.
Where are you in your treatment?
Well, I probably could graduate the end of September.
And then what's the plan?
I'm trying to find a place.
You're not going to be living with your mom?
I probably will for, you know, until I can find somewhere to go, but I really want, you know, Haley to be in a program because I feel like that will be the best thing for both of our situations. It's a lot whenever she's going through that. It's a lot on me. So I'm just taking it day by day to see what's going to happen afterwards.
Well, if you remember, I pulled strings to get her in there before and she left.
I know. I know.
So.
But if not, I know.
Throw that up, but yeah, she was there before and left and had to go. She went to the counseling center and
right.
Now she's trying to get back in Project Hope, which I think would be a good place for her.
Right.
I think maybe she's ready for it now, where she wasn't before.
Right.
Time will tell.
Right. But
You got to stay clean and sober too. I see you as the linchpin.
For sure. I appreciate everything you've done for us.
I mean, there's a lot of people dependent on you.
Absolutely.
Haley and her kids, your
Right.
mom. I mean, it's just like spans out from you, all these people that you're touching, and your sobriety is so central to their life.
Absolutely.
So it's not just about you. Well, for none of us, we all have people that we affect, but you in particular, you're right at the center. This is your time in life. I mean, where you got to be. I know it's a lot, but it's what you're here for. This is the main thing, main time. This is prime time. You got to do it.
You got to be a rock.
I know.
Okay, so I think you're on the right track. But you got to keep working at it.
I will. I appreciate it.
Okay, another month?
Yeah, I think Haley comes back Monday to see you.
Okay. Well, you're welcome to come with her if you want. September the 16th, we'll see you.
All right.
State of Ohio versus Kathy Knight, case number CRB 24-147-8.
She's asking if might consider removing the ankle bracelet.
Just have a seat. Let me check with a resource on that, and then I'll let you know.
Thank you.
right, good.
Oh, yeah. Good. You look better today. It's smell on your face, that's good. Maybe your screen's good, too.
This is Kathy Knight, 24-147. Mr. Morford's the attorney. She's at Bethesda.
She's doing well, Your Honor. She helps out a lot with planting the flowers and taking care of them around the, so she keeps herself busy and she stays dedicated, so we don't have any problems out of her at all.
Very good. Great report. When do we need to come back?
Month or so.
Month. September 16th?
Thank you, Your Honor.
You're welcome.
Thank you, Judge.
You want me?
State of Ohio versus Caitlyn Moore, case number CRA 24-243, CRB 24-244, CRB 24-337.
They're going to know it, but this was by our state agency or was under continuous treatment there.
This is where you've been.
I've been going to both. The Marshall psychiatry is from Logston.
Judge, Mr. Hill and I have had extended conversations about this case, and I think our agreement would be to continue this matter until after the case that's been taken to the grand jury has been settled. I have here for you, she has been seen at Prestere. She's counseled there. She has been counseling there, and I have, this one is a couple months old, but she also goes to this Marshall Health. And she's been working on the issues that have been identified by her providers, Judge.
The Marshall Health letters from a long time ago.
May.
Prestera says she has an appointment.
Mr. Hill?
Your Honor, Mr. Hinkle's here. He has recently provided me with a whole lot of what he says are records of further violations of the protection order. I've encouraged him to get with law enforcement, and if there are valid and provable cases, then there'll be new cases filed. It's also my understanding that Ms. Moore has gotten a protection order against Mr. Hinkle in West Virginia. So they each have protection orders now. And one thing that Mr. Hinkle, and I think that I understand why this is an issue, they have children together. So he contacts her for the purpose of the children, but it seems to me like because the last time they were here, there was discussion about they went swimming together and things of that nature, that it can't help cross over the line sometime. These people are in a high conflict situation. There's also a felony charge pending against Ms. Moore in common pleas court having to do with assaulting somebody after entering a house without permission. Don't know how that's going to play out.
Is that in process? Or
Yes,
already
there's a pretrial coming up on that, I believe, on
It's next Wednesday.
next Wednesday.
We waive from here, Judge.
So what we wanted and what we discussed the last time we were here is that Ms. Moore was going to attend to her mental health issues and needs, which apparently at least she's got an appointment at Prestera. We'd like to have something a little more detailed than that. And I know that Mr. Hinkle is anxious about this whole thing. There's a lot of entanglement between these two people because of their children. And I also have been told by Mr. Morford that Ms. Moore has records showing that Mr. Hinkle's been calling her, but he says it's because we have children together. It's hard to know where the line is on what's violating and what's for the benefit of the children. So.
This is going on in 3 states, Your Honor: Kentucky, West Virginia, and now in your lap.
Well, the only thing I can do is address what the charges are in front of me. It sounds like the root of it, though, is more serious than what I can address. How old are these children?
2 9-year-old girls and a 3-year-old boy.
Wow. You guys need to figure this out because you got a long time to go.
Yes.
To have to deal with each other. And it's not great for your children either that you're having all this conflict. So, without judgment as to who's responsible, because I don't know the evidence. I know that. I know that parents fighting has adverse effects on children. So, who's at fault for causing it? I don't know that. But I guess we'll get to that if we have a problem. When you're dealing with each other, you can think of, well, now what's best for my children, not what's best for my feelings right now, what's best for them in the long run. That's where you're focusing. So how are we going to proceed here then? I don't know if this really, we're wanting to wait till some of the other charges resolved, or?
We would, I think that that's the best way to proceed from our perspective.
I would concur, and we would waive time, Your Honor.
All right. Who's representing Ms. Moore in common pleas?
I don't know if I will or not, Judge.
Oh, there hasn't been a lawyer appointed yet?
Have you been arraigned yet?
What?
Burglars.
Yeah, it's set for a pretrial.
Yes.
Who is your lawyer?
You.
Okay, I guess I did get appointed.
Okay. When's the pretrial in common pleas?
The 21st. And our divorce is the 20th.
Okay, so maybe September 6th would be a good date to come back here? May have some clarity.
Yes.
That would suit us, Your Honor.
I believe that's good here, Judge.
All right, September 6th will be the next hearing, pre-trials on both cases.
Yeah, if you want to pass that.
Thank you, Your Honor.
You're welcome.
Thank you.
You're welcome.
State of Ohio versus David Vance, case number CRB 24401.
The Morford case, pre-trial, advance.
she does not want a protection order. They have a divorce pending.
Yes. She's in the process of getting
I have the paperwork, I just haven't filed it yet. I've been trying to wait until I can work out the shared parenting with her.
Okay.
It's the only thing that's not been done in the divorce papers is the shared parenting where there's been the protection order. I'm not able to work it out with her.
So, Your Honor, in speaking with Ms. Vance, she plans on getting a divorce, filing a divorce soon, and they are not going to be together, but she does not want a protection order, and she's in agreement that this matter could be resolved with a dismissal after about 90 more days if there are no further problems, and the court costs are paid.
Agreeable here, Judge.
Okay, I'll set this for November the 15th. It'll be dismissed then if there's no further problems. Costs are paid. And so protection order, she doesn't want a protection order, is that what you said, Mr.
Does not, yes.
So there had been one issue, but I'll drop it now. So the protection order's over
When will that take effect, Your Honor?
today.
Thank you.
So if you pay the court costs, there's no further problems, you don't have to appear on November 15th. You just have to pay the costs and make sure there's no further problems. If there's problems, then you gotta appear. Otherwise, you don't have to.
How much is the court costs, Your Honor?
It'd be 150.
150.
Yeah, payable to the clerk.
Thank you.
Thank you, Your Honor. You're much welcome.
State of Ohio recalls Amanda Hicks, case number TRD 12-1804, TRD 12-456, TRD 08162.
All right, on Amanda Hicks, she wants the GPS monitor removed. We're going to agree with that. You can see Mr. Major about getting that done. Keep your hearing date for September 16th.
For sure, thank you.
Thank you, Judge.
Butch.
State of Ohio versus Heather Fowler, case number TRD 24997. Heather Fowler, recall. Heather Fowler.
Sorry, couldn't get in there.
This is Mr. Morford's case. Pre-trial. It had been set for pre-trial August 12th. She wasn't here.
Judge, you mind recalling?
Okay, this case will be recalled.
State of Ohio versus Richard Blaine Flowers, case number CRB 24465. Richard Blaine Flowers.
Richard Flowers. Mr. Thompson's case. Mr. Thompson is not here. He was supposed to go to Bethesda, but I don't think he did. Taylor, you know anything about that?
He did not.
Okay, so there'll be a warrant issued, yeah, the OR bond up, so bench warrant issued for failure to appear and for leaving treatment.
State of Ohio versus Kazy Lynn Blevins, case number CRB 24488 A and B, CRA 24487. Preliminary hearing.
Okay, this is Mr. Smith's case, preliminary hearing. My notes were she was at ODT.
Yes, Judge, she was right here.
Yes, I'm still there.
Just as a shoplifting, criminal trespass, and identity fraud, which Mr. Hill and I have talked about the weaknesses in going fraud and identity fraud, but I think the state's position would be to leave that felony open, interplea today with the misdemeanors, go through treatment at the end. There's a good likelihood the felony is going to go away if she's compliant and does what she's supposed to. Fair enough.
And she is compliant with treatment, Your Honor. She's due to complete our program on September 7th, and so we're still working on her aftercare.
Okay. Thank you for that report.
And we want her guilty plea judge to the 2 misdemeanors and delay sentencing until sometime after September 7th.
Okay, so she's pled guilty to the CRB case numbers.
Correct.
CRA will remain open. That's a felony. So hopefully what will happen is that just goes away. They'll dismiss it, and then the main thing is we want to get you into recovery and make sure you're equipped to stay there after this is over. So inpatient is good, but you're going to need to do some follow-up after you transition out of that. About 16th, and she'll have been out a little over a week.
September, Judge?
Yes.
Yes, I can do that.
And where will you be going? You know where you'll go?
We've discussed it briefly. We're waiting for the treatment team to come up with a recommendation and everything like that, and then we'll move forward. I know she is interested in outpatient, but we haven't got the recommendation from treatment team yet.
Okay. September 16th will be your next hearing, preliminary, at 9 o'clock.
Thank you, Judge.
You're welcome.
Thank you, Your Honor.
You're welcome.
Yes.
State of Ohio versus David L. Mills, case number CRB 23758.
Mr. Smith's case?
Yes, Judge.
Pre-trial under review?
Yes.
RRS?
He
Then
was,
Southern Notice.
yes. Yes, sir.
Your Honor, that's just really a letter of attendance stating he's with us. He hasn't been there very long, and then he caught COVID, so he was in the hospital for a minute.
Okay.
So we haven't really had an opportunity to get him in continuity of care with his individual counselor, but he's doing well. He's complying with all housing guidelines.
Okay, so come back and,
I'm good anytime in September, Judge, except the 20th.
All right, let's make it the 16th. 1 month exactly, September 16th. Come back. Looks like he's on the right track now. Pretty tall, 10 o'clock, September 16th.
Thank you, Judge.
You're welcome.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Virginia M. McGlone, case number CRA 24498 A and B. Virginia McGlone. Virginia McGlone.
And she was at hometown, but I think she left and went someplace else.
Your Honor, she was never at hometown.
Well, that was my notes, where she was supposed to go.
Well, this was a case where she had a Portsmouth Municipal Court holder.
Yeah, I think she has a case there, doesn't she?
Yeah, you released her you gave her a signature bond here. She appeared in Portsmouth Municipal Court as Virginia McKenzie, which created some confusion. So she's Virginia McKenzie up there, Virginia McGlone here. Same social, same date of birth. She was given a signature there by Judge Mallory, released from Sauter County Jail. There was word that she went to Ascend.
Ascend? Okay, yeah, she went to Ascend in Portsmouth. Kim sent me a text on it.
Yeah, is that where she's at now?
I am not sure what's the last one.
Yeah, I'm not sure if she's there or not, Your Honor. She was instructed by this court to go to hometown.
Right.
And actually, I told the court in Portsmouth that exact same thing. I couldn't be there for that arraignment, but I did go before court and talk to Judge Mallory about that and told him she needed to go to hometown, and he was going to give her a signature bond like this court did.
Do we have any contacts with this? I don't think I've dealt with this Ascend in Portsmouth. Does anyone else?
Your Honor, I'm from Sauter County and I very rarely deal with them.
I know the representative from Ascend. She used to come here some, but she's in the other courts in Portsmouth that I'm in.
Can we contact her to see if Virginia is there?
Yeah, that's actually who called me the other day.
Okay.
And it might be Virginia McKenzie, not Virginia McGlone.
Yeah, she'll know what I'm talking about.
Okay.
Can you find that out for us then?
Yes.
And we can recall.
We'll recall. All right, we'll have him do some research.
State of Ohio versus Andrew Curry. Case number CRA 23464 ADSA, CRB 23463, CRB 23291, CRB 2361, CRB 22351.
Mr. Steyer is representing Mr. Curry. Thank you. Yes. That's a good report for Mr. Curry.
Yes, it is, Your Honor, and he reports as well that he's been clean for 30 days now.
I got my thing.
Looks like we're finally getting some rain. Okay, well, good job. I think you're where you need to be and doing what you need to, so just come back on the 16th of September.
Yeah. And Your Honor, although he points out that he's been in treatment, he can't take responsibility for what's been done. It looks like some cleanup's been done at the house. He has some photos for me. I'm going to show these to Mr. Hill.
Yeah, well, that's.
I think he's already seen them.
Okay.
The other, the co-defendant was here already.
Okay.
Tony showed you those.
Yep. I'm sure. I guess that's my file too, sir.
Yeah.
That's part of my felony.
Right, I understand. All right, the main thing for you to focus now is on your recovery, and we'll see you in a month. You know what to do.
Okay. Thank you, sir.
Did we get a date specifically?
September 16th.
16th.
Yep.
I have a jury trial that day, Your Honor.
Okay. How about the 13th?
I'm available that day.
September 13th.
Thank you.
Your Honor, we're ready for that Lawrence County Jail.
Okay, we're going back to the jail for some follow-ups.
State of Ohio recalls Melissa D. LeGrand, case number CR 24515 and others.
Okay, we have Taylor, you want to come up? See, can you give this to Taylor? Is this sufficient to get us where we need to get?
This will take her.
Okay, we've got a place for you to go, Mr. Graham. And she's going to need some mental health help too.
We'll get on top of that.
Okay.
All right, I'm going to let her sign a $5,000 signature bond with an order to go to Bethesda for inpatient treatment. Do we need an ankle monitor?
I think so, Your Honor.
Okay, well, we're getting one taken off, so we should have one available to be put on. I don't know if it'll happen today, it's 2 minutes till 12. I'll order her released with the GPS monitor to Bethesda for inpatient. Somebody will need to contact adult probation, see if that can happen today. Mr. Morford, you're appointed to represent her.
Thank you, Judge.
When do we want to come back? We'll put it on the docket for Monday to make sure what's happened with it. With this case. Here Monday. Let's put it on the docket for Monday the 19th so we can track, make sure she is at Bethesda.
Thank you, Your Honor.
So you're going to go to your treatment program, Ms. LeGrand, hopefully today, but I can't guarantee it.
Okay.
It may be Monday.
That'll be great. Thank you, sir.
You're welcome.
Thank you, Your Honor.
Thank you, Judge.
State of Ohio recalls Toby Pack at the Lawrence County Jail, case number CR 24326.
I see you, sir. I've got a note, basically, the person that does governor's warrants in the Wood County Commonwealth Attorney's Office does not work on Fridays. So you should try to get that job if it becomes available. Let's put it back on the docket for Monday.
Thank you, Your Honor.
So August 19th will be your next hearing.
Thanks, sir.
You're welcome.
State of Ohio recalls Harry M. Roode at the Lawrence County Jail, case number CRD 21392, CRD 22805.
Mr. Morford's case with Mr. Roode. You were going to talk with him by phone. Harry Roode. Who's still on deck? Is there anybody on deck?
Yeah, Hunter Tooley.
Tooley will be after Mr. Roode. So, you had a chance to talk to Mr. Roode?
Yeah, sure.
What's he want to do?
Trying to figure out that right now. did you leave RRS?
Do what?
Did you leave treatment? Prosecutors want to know if you left the treatment, sir.
How he ended up in jail.
He had failed to appear. And I think he had a bond up in Mr. Sowers.
Judge, with respect to
He told Mr. Sowers some things I sent you in the text I thought were troubling. Maybe treatment would be an option for him.
With respect to STA, Judge, he simply forgot.
Or did you read the text?
No, I haven't.
Okay, well, please read it. I just sent it to you maybe half hour ago. Well, it's actually forward from Mr. Sowers.
Mr. Roode, are you interested in going to treatment, sir?
Yeah, can I do outpatient?
That would depend on the assessment, sir. If the provider assesses you and makes a determination as to the level of care you need. That's out of our hands. That's in the hands of the provider. Whatever they say is what the court will order. What's your pleasure, sir?
I mean, I can do the treatment for alcohol, yes.
You can do the treatment what?
For the drink for my alcohol.
Okay.
I think there's more involved in alcohol, serious enough, but I think there's more involved in that. Where are you living now? Are you in Chesapeake?
I'm in Proctorville.
Proctorville?
Yes, in place.
In the village or where? Where do you live in Proctorville?
On Church Street, Southwest Fairgrounds.
Okay. Well, probably OVP in Parkville is the best to start with. Let's get Mr. Mint in. I'm sending you a copy of the text that this is from Mr. Sowers, the stuff that he said. This is Mr. Roode, Harry Roode. Mr. Sowers picked him up on the pond, failed to appear. So you got a history from what he says he told him. I'm gonna let him try outpatient first. He lives in Proctorville, but I suspect that's not gonna work.
Probably not.
Okay, good.
We can, if you're gonna allow him to do outpatient, are you wanting him to go through OVP?
Yes.
Okay. Well, I can
Will
get
you
it.
agree to go to inpatient if you fail outpatient?
Yeah.
Now, I'm told that your wife's got a problem too, is that correct?
She does.
Time to be honest, sir.
I mean, she's not before me, I can't order her to do anything, but you are. It's probably not gonna get you straightened out till we get her straightened out too. Mr. Sowers tells me that alcohol is a big problem for you, but methamphetamine is too.
Yeah.
Are you not willing to go to inpatient, Matt, if you can come to OVP for 30 days?
I can't do inpatient.
Okay.
You
well-
can do inpatient, you don't want to do inpatient.
Well, it's not bad, it's, yeah, I come away from my house, so people break in it, but can't. I've had my house been broken into like 4 or 5 times already. They just hit me the last time I was in jail back in, June, I believe, yeah, June. They busted the window back to my house.
Okay, well, I'm gonna let you try it, but just for a couple of weeks, and then we'll come back and see where you are. So I'm not letting Mr. Sowards off the bond, so you know he'll come and get you if you don't show up.
He knows exactly where you live, too. I've accompanied him there.
Okay, August 30th, we'll try outpatient. I'm not gonna have a good feeling about it. How do you want to talk to him while he's at the jail? How do you want to?
Yeah, I can call and talk to him, and we'll get his appointment scheduled and everything, and just go from there.
Okay, she's gonna call down and talk to you here in a few minutes. And you're gonna go to the ODP in Proctorville. So I need really good reports if you want to stay there, not go inpatient.
Thank you, Your Honor.
Thank you, Judge.
State of Ohio versus Hunter E. Tooley on a recall from Lawrence County Jail. Case number CRB 24385 A and B, CRB 24329, CRA 24328, CRB 24292, and Jaren Edington is on deck.
This is Mr. Morford's case, all of them. Mr. Tooley was set for pretrial August 5th. He didn't appear at that time, and I believe he had left treatment prior to that.
He says he wants to return to treatment if they will take him back.
He was at hometown.
Yes, Your Honor, we didn't have any issues with Hunter besides him taking off, so we would have the authority to take him back.
Okay. What about Grandma? What do you say? You're not gonna go pick him up though, right? If he calls somehow and says, Grandma, come pick me up.
No, I only picked him up because he was allowed to come. We went to eat dinner.
Okay.
And he decided, he said, Mom, I can't do this anymore. You got out of the car and left.
When he did leave, she did show back up to our treatment facility and tell us what happened, so
Okay.
she was very concerned, so.
All right, so you weren't enabling him to leave. All right, Hunter, you gonna stick it out this time?
Yes, sir. Yes, sir. I left because I smoked weed. I knew I was going to have to pull a drug test. I got nervous. But I went to come up in court, but I was like 30 minutes late, so that's why I went back to jail. But I did show up, it was late. You know what I mean? I waited on around.
Okay, they're willing to take you back, so I'll give you another chance, but you're starting to run out of chances. So I'll order him released to hometown recovery. Yeah, 5,000 OR bond. And then let's come back on him. Let's see, how bad's August 3rd? That's okay. August 30th will be his next hearing.
I've got them, I'll tell you what, I've got them written down. I've got them on my notes.
Okay, so you'll be going back to treatment. I'll see you in 2 weeks. Get a good report. Do what you're supposed to do.
Thank you, Judge.
State of Ohio recalls Jaren R. Edington at the Lawrence County Jail, case number TRC 231190. The order of the jailers has informed me he's told them that he cannot provide here for your statement.
I don't believe that. wasn't born yesterday. All right, Mr. Edington, I'm going to be here for a while, so here's your choices. You can provide a urine screen before I leave the bench, or you're going to sit there all weekend, and I'll see you Monday.
Okay.
Deal?
Yeah.
I mean, you're a young guy. I think you can provide a urine screen if you want to. If you don't, then don't. But you're going to stay in jail. I'll recall this later in the docket.
Butch. So let's finish the jail at this point.
Okay, that finishes up at the jail for now. We'll come back to him later.
State of Ohio versus Brian R. Marksberry, case number CRA 24362.
All right, this is on the docket as preliminary review. You're supposed to be in treatment. Are you in treatment, Mr. Marksberry?
Yes, I am. I brought a progression.
Okay, we need to see what you got.
Yeah.
All right, is Kathy Haycock here?
Yes, she is.
All right, ma'am, would you come out and talk to the prosecutor? How's the statement received?
It's my understanding that Mr. Marksberry is enrolled at OEP for...
No, it's someplace in Columbus, I believe, so right?
No, it's
It is
OVP.
OVP?
Yeah, in Ashland.
In Ashland, okay.
They are residing together at this time, and she says that they're... Did I say that?
Yeah, I mean, it's not the greatest thing, but
They're coexisting at this point. And as long as there isn't an outbreak of violence, then I guess that she's still staying there for the time being. We want him to continue in the treatment. She does not want a protection order. And if he wants to do it that way, we would ask for another time waiver.
So, ma'am, from what I'm seeing, the treatment is focused on anger management. There's nothing, although there's some past mention of substance issues, it doesn't appear that the counseling now is directed toward that. Do you think that needs to be a component of this? No? Okay. You're satisfied with what he's doing? All right. Okay, so we'll continue with your treatment. Come back in a month on September 16th. Bring me another report just like this one.
Okay, sure.
It's very detailed.
Okay.
Okay.
Thank you.
September 16th, 10 o'clock.
And I'll need Mr. Marksberry to sign this one.
State of Ohio recalls Virginia M. Glynn, case number CRE 24498,
Your Honor, Ascend sent her to Foundations to detox,
Okay.
and we confirmed that's where she's at right now. So if we want to set this in a week, and we'll have her here.
All right, the 23rd, so August 23rd. Next hearing for Mr. Glynn. So she still should wind up maybe at hometown.
Yes.
Oh, okay, okay.
Well,
I don't know anything about this Ascend. I need some more information if she's going to wind up going there.
I think she probably should go to hometown. So if we just maybe instruct him to, after she's done with detox, to go to hometown.
Okay, so she's at Foundations now.
She is. So,
All right, next hearing is August 23rd.
after she's done, she needs to go to hometown. I got you. Okay, not Ascend. And Ascend's outpatient anyway. I don't realize that.
I think Ascend has it.
Okay, well, she's going to go to hometown.
I got you. August 23rd.
August 23rd. Thank you, Your Honor.
You're welcome.
State of Ohio versus Alec Barry, case number TRC 24611, TRC 23957, A and B. Alec Barry.
Smith's case, sentencing.
Here's the one we can see. It's the date. 23rd.
Now pressure on her. Yes. Good report. Does he have anything to pay with his OBI?
Your Honor, can I ask how much I have on fines, like, total?
On 655.
Total?
Yes.
Okay,
Well, I mean, you pay $25, $50 is all I'm showing.
Okay, I'll pay 150 today.
Okay.
So he's paying 150 today. It looks like we're with a good report. I guess we'll just
He continues to remain compliant, Your Honor.
Okay,
continue the sentencing, let him,
September 16th,
that's fine, Your Honor.
sentencing, and basically it's a review hearing on the previous case.
Thank you, Your Honor.
Thank you, Your Honor.
State of Ohio versus Continent Gomez, case number CRB 24416.
Sentencing, Mr. Smith's case. Excellent report. Getting ready to finish up.
Yes, sir.
Continue on, he's got a bond up, so I'd like to keep it pending while he has the bond. So there's gonna be a plan for after care.
Yes, Your Honor. He is scheduled with OVP outpatient in Huntington and he leaves our program on Monday and will continue to follow up there. Originally, we were recommending further treatment, but we've decided to give him the opportunity to try outpatient first. And I've explained to him that, you know, we're giving him the opportunity, but if he messes that up, he will have to go to long-term treatment.
Okay. Well, if that's the fact, then I think maybe we need to come back sooner than later. How about September 6th?
That's fine, Your Honor.
That's fine.
Next hearing, September 6th.
And then if we can, Your Honor, we had received paperwork from the court, a copy of his court order, but it looked different than the ones we usually get, and his insurance isn't accepting that.
Okay.
So we need like an updated copy of the court order if we could get that.
Okay.
What, when we take the judgment entry on this case, I'm not sure what.
Let's just, you do an order on it and do it as if it's July 19th. Non-pro-tunc is the full word.
There was one done on July the 19th, but all it says is inpatient treatment.
Right. We can say it's a part, he pled guilty and then sentencing is delayed while he attends inpatient treatment. Bond remains in effect. Hopefully that'll get it. All right, September 6th, the next hearing at 10 o'clock.
All right, thank you, Your Honor.
Thank you, Your Honor.
State of Ohio versus Howard Thornton, case number TRC 24530, A, B, and C.
Cyrus case for sentence. He said RRS. Yes.
September 16th. Let's get it 6th. The other one I had. Alec Barry, it's the 16th.
So second offense OVI, pled guilty May 13th. He's been going to treatment with RRS since then. He's got an excellent report. So I don't think he's finished, but
He's not finished, but coming up on it.
okay.
And Your Honor, I think, looking at my notes. One was the 2017 conviction was an unknown court in Kentucky, and the 2014 conviction was one in Judge Collins's court, where there was actually not a finding of guilty. So for purposes of sentence enhancement, it does not count as a previous conviction. That's a matter we had dealt with before, so there was an agreement that if he did well in treatment.
Saying Judge Collins would agree with that?
I don't think he would, but I think that there's case law stating that he's wrong on that.
We had
Did the
discussed.
Court of Appeals ever disagree with him though? I mean, it's like,
I don't know if he was ever taken up on the issue, but there's case law that basically says that, and I can't remember the rule number, there's a rule number that describes what has to be in a guilty finding to count as a conviction.
and it wasn't there.
And it's not there. For years he was using forms that basically said, well, I've got a copy of it here. It says, the defendant enters plea of guilty, which the court accepts, the court sentences the defendant to, but never states that he's found guilty. So
Nobody ever realized it until Luke came along.
well, no, actually, this isn't mine. I think Mr. Cremines figured this one out.
So we had discussed all this previously, and we had agreed that it would probably be no more than a second, just because of those things. But he also had he didn't have a test, yeah, right, but he had a PBT of 353, so we kind of were concerned about his well-being. We want him to do well.
Well, his reports are very good, so.
Yeah, he's had great reports every time.
Okay, well, let's keep going, and let's look. I've set several on the 16th. And that's, was that the date that you were unavailable? You had a trial?
Which date did you say? 16th. 16th, I have a trial.
How about the 20th?
20th, I'm available.
September 20th will be the next hearing, sentencing.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
State of Ohio versus Donald. State of Ohio versus Donald J. Wilson Jr. Case number TRC 072723 A, B, and C.
All right, this is an older case that Mr. Wilson is trying to take care of. He's been making payments. You got community service to do too?
No, it's done.
It is?
I believe it is, Your Honor. I have to double check, but I'm pretty sure it is.
Okay. You have a payment today?
No.
Okay.
I get paid once a month. I'm on disability. I already made that payment this month.
September 6th will be your next hearing.
All right, sir.
For sentencing, 10 o'clock.
Thank you.
You're welcome.
State of Ohio recalls Heather Fowler, case number TRD 24997. Heather Fowler.
Mr. Morford's case, it was pre-trial August 12th. She's here today.
Judge, I'd like to ask you for maybe 30 more days. She has fallen on hard times, homeless, doesn't have a job right now. She expects to be able to come up with the money to get her driver's license back within that time period.
Where are you living, man?
Well, I just got in contact with my mom yesterday, and she told me that I can stay with her.
Okay.
So that's excuse me?
Is she local?
At Proctorville.
Okay. Well, that's the address I've got on you, is Proctorville.
Yes. So I'll be going back there. I'm in the process of moving back in with her now. And then she told me that if I talk to my dad, that she has talked to him, that he would help me with the fines that I need to get my license.
Okay. Well, that sounds like I was going to say, you can always go to the Huntington City Mission. If you're down and out, don't have a place to stay, you can always go there. But it sounds like staying with your mom would be a better option.
Yes, they seem to be overfilled there.
Well, they have a lot,
Yes.
but they don't turn people away, they don't kick you out, and they will feed you.
Right?
The Ironton mission is like, they only let you in at 8 o'clock at night, and they kick you out at 8 in the morning, and they don't feed you.
Oh.
Library or Wendy's, Glynn said.
So, and they do have some programs to try to give people jobs and more stable housing, and so, yeah. So that word needs to be out. I think it is with a lot of people, but, okay. So another month or so, Mr.
Please,
September
Judge.
20th is the next hearing.
I'm good then.
Okay.
State of Ohio versus Bruce Ward, case number CRB 15-268, CRB 11-435, CRB 10-1087.
I will be here. Thank you so much.
You're welcome.
Thank you. I have put some paperwork in the property and Wright.
Okay. All right, so you've just got some old cases to take care of.
Yeah,
Looks like
yes,
you were
sir.
tied up for a while.
Yes, sir.
So you're back, you're living in this community now? or-
I'm in Bidwell, Ohio.
Bidwell?
Yes, sir.
Okay,
The address on on this paper here, my address is on the bottom of it.
okay. Is that one of the things that you gave the clerk?
Yes, sir. Yes, sir. I had copies made of both of them.
Well, Bidwell's not that far away.
No, sir.
That's Gallia, right?
Yes, sir. I'm about 5 miles from the hospital.
Okay. Well, what can you, we'll accept anything you can do to get it taken care of.
I made a $5 payment today, sir.
All right, that'll work. Just make an effort.
I'm gonna get a couple of papers because I've got some community service and get that all taken care of.
Okay, I'll set your next hearing for September 20th at 9 a.m.
Thank you, sir.
You're welcome.
State of Ohio recalls Jaren Edington at the Lawrence County Jail, case number TRC 231190.
Okay, you tested positive for marijuana. Anything else you want to tell me, Mr. Edington?
In regards to what, my case or?
Yeah.
I mean, I don't really know. I mean, I can work on getting my community service and my 3-day course and get it scheduled and stuff.
Yeah, that's what you need to do. What's going on with you? Are you going to school, working, or what are you doing with your life?
I was working for a while, then I got fired. I was working at Walmart. But I mean, I put in, like even this past week, I put in applications to get a job, another one.
Well,
So I've been actively pursuing, trying to get a job.
there's jobs out there if you want to get them. Some of them are not the greatest, but it's always easier to get another job when you've got a job. So I'd say take maybe one that you don't like and then try to build up from there. You got to take care of this stuff. I mean, you got 5 days community service. You still, looks like somebody paid your fines off for you. And you got to go to the 3-day school. So I'll find you in contempt for not coming to court when you were supposed to before, sentence you to time served. And now you know this is not optional. This stuff is mandatory. You've got to do it.
Yes, sir.
You understand that?
Yes, sir.
And if you don't show up for court, what happens?
Be right back here.
You go to jail, you get a warrant for going to jail. It's not like, as I say, it's not like 7th grade math homework. I really didn't feel like doing that, Mr. Smith. Well, that's okay, Johnny. We don't really care if you do your math homework. It's not like that. Okay, do you understand? This is adult stuff. You are a full-grown man now. Fully grown. With fully grown man responsibilities. I know in our society we don't treat you like that because how old are you?
41.
You're 41? You are a full-grown man. Man.
21.
21, okay. I was gonna say, you don't look that old. Okay, 21, 50 years ago, we treated 21, my dad had already been to Iwo Jima and back when he was 21. And now we treat 21-year-olds like we did 12-year-olds back when he was growing up. But this is over now. I'm like old school. So you're going to go to jail if you don't do this. Do you understand?
Yes, sir.
And you got a taste of it. You don't want to go to jail, do you?
I'd rather be doing a couple more things else than doing this.
I don't want you to go to jail. I don't like going in there and visiting. So, act like you're afraid of going to jail.
Yes, sir.
If nothing else. So, you're going to get out here in a few minutes, and then you got stuff to do. Your 3-day school, and you got your community service. You do it any day here at the court at 7:30 a.m. In fact, I think it'd be great if you showed up tomorrow morning.
Yes, sir.
Okay, 7:30, right here for community service.
Gotcha.
Cut a little grass, pick up some litter, it won't hurt you. So is that wrong, ma'am? I see you don't like it. He said
here.
No,
Yes, it's your.
I don't know, I'm guessing. He said since September the 5th of 2023, he hadn't done one daggone day yet.
He's 21, he should have his hind end doing it on his own.
I agree. That's why I'm trying to get him out here to get it done. And maybe I misread it. I thought you was like, wow, he's making him come out tomorrow? Yes, I'm making him come out tomorrow.
That's fine. We'll be here. He'll be here.
That's part, it's not we,
We
it's
will be at
him.
Kings Island at 7:30 in the morning. He will be at community service.
I agree with that. He doesn't need to be going to Kings Island.
No.
Okay, so you'll be here tomorrow morning for your community service. Your next hearing is going to be September the 16th at 9 a.m. I'm giving you a month. Once you get this done, you don't have to come to these hearings anymore. Okay?
Yes, sir.
You can't stay, you don't have to go home, but you can't stay at the jail. And you don't have to pick him up, but he's getting kicked out of the jail here shortly.
Sounds good. Thank you, sir.
You're welcome. Oh. Just put it in the file. All right.
State of Ohio, Jaren R. Stover, case number TRC 24674, A, B, and C.
There's gonna be a chair, Jared.
Okay, so we've got a motion hearing today.
Got my witness in here, Your Honor.
All right, everybody's ready to proceed?
Yes, sir.
state, ready to proceed?
Yes, Your Honor.
You swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You may be seated. Mr. Field.
Thank you, Your Honor. Trooper, can you state your name and where you are employed?
My name is Trooper Barnett. I'm employed at the Ohio State Highway Patrol with the Ironton Post.
Were you working out of the Ironton Post back on April the 2nd, 2024? And were you on duty around 11 p.m. in the evening?
Yes.
And at that time, did you have occasion to come into contact with Jared Stover?
Yes.
Do you recognize Jared Stover in the courtroom? And if you do, could you point it to him, please?
Yes.
Verdict will show you pointed to the defendant.
So what caused you to come into contact with Mr. Stover?
I was dispatched to a rollover crash on County Road 31.
Is that in Union Township here in Lawrence County, Ohio?
Yes.
So that evening, what were the weather conditions?
On my way there, there was a heavy rainfall, and then when I arrived on scene, there was still a heavy rainfall.
So when you arrived on scene, did you locate the crashed vehicle?
Yes.
And describe what the conditions of the vehicle were, what situation it was in.
It was on its side, on the right side of the roadway, butted up against the guardrail.
Did you locate Jared Stover at that time?
Yes.
And did you ask him what happened?
Yes.
What did he tell you?
I don't recall his exact statement of what he told me what happened in the crash, the reason for the crash.
Were you able to determine that he was the driver of the vehicle?
Yes.
The roadway itself, was it on a curve or a hill or anything that might...
It was curved. It was a curved roadway at the time.
Pavement was wet?
Yes.
Did you ask him if he had been drinking alcohol?
Yes.
What did he say to you?
He said yes.
Did you ask him how much alcohol he had had to drink?
He said a few.
Did you notice anything physically or about him that would maybe indicate also that he'd been drinking?
The odor of alcohol. I detected that.
Now, at that time, did you have any, were you beginning to form any suspicion that Mr. Stover might be impaired by alcohol?
Yes.
Was there anything else right at that moment that you can think of that led you to that?
It was the odor of alcohol and the admittance to drinking that night and the bloodshot glossy eyes.
Did the crash add to your suspicion?
Oh, yes, and the crash and time.
Now, was your patrol vehicle equipped with a forward-facing audio-video camera and then a camera that faces the back seat of the cruiser, and then were you wearing a body camera?
Yes.
Were they all working at that time?
Yes.
Did they all record the incident that we're here about today?
Some parts, when I pulled into the crash scene, I pulled up into this driveway. I don't recall, I don't think the front-facing camera got the field sobriety portion of the test.
Okay. But you uploaded what you had.
Yes.
So you're saying that when you did the field sobriety test that the forward-facing camera was not able to capture because it wasn't on?
It was on.
Okay, just facing a different
It was
direction?
facing a different direction.
Okay. Did your body camera capture that?
Yes.
Right. You preserved those recordings for our use here in this case, right?
Yes.
video showing when you first arrived there?
Yes. That, yeah, that was clicking on when it beeped.
Now, I want you to look up in the upper right-hand corner and tell me, it's up here, what time it was.
It's 23:10.
Is that 11:10 p.m.?
Yes.
And do you know about what time you were dispatched? Do you recall?
I don't recall the exact.
Just like the crash scene. Good bit. Real quick. Okay. It's not picking up the rain again. That's pretty good. Yeah. What happened? I come around here and I hydroplaned. I get up and it's, I don't know if I hit the gas too hard or what, but come sideways, come back, and roll. Anything break on it? Yeah. Okay. All right. Well, one more run 50 test and go from there, okay? That's fine. All right. If you want to just have a seat in my car for a second, I gotta do a few things, all right? That's fine. Just so you get out of the rain while I do all this. All right. Let's go back down real quick. All right, I'll just put my front seat. Don't want to forget. No, I'm not worried. I'm not worried yet. How much you have to drink? Few. How many is it few? Can we walk over here? Oh, that's fine. All right, man. Oh, you're good. I'm just trying to get you to stop so I can walk home. You know if you have anything? I'm participating. I just smell pretty good. I work with DMT and both this split up in the world and all right, I'm just going to patch down some real quick. Just make sure you don't have any left. What's that in your pocket right there? Yeah, what was that? Wall? Can't snuff, wall? What's in my pocket? Keep that. Chapstick, what's like it? Alright, thank you. Have a seat there for me real quick. Have a seat back there, get you out of the rain. Alright, that's good. How do you want the tub? How do you want the tub? Nice, okay.
So you had Mr. Stover sit in your patrol vehicle. Was he under arrest at that time?
No.
Why did you have him sit in your vehicle?
Because it was rain. I had to get him out of the rain. And I still had to do my steps for the crash and everything of that sort.
Did you handcuff him at that time?
No.
Now, did you shut the door?
Yes.
Why did you shut the door?
So the rain won't get inside the vehicle.
So after this, did you start to conduct, I guess, crash?
Yes, I
report?
started doing my pictures, my photos, and my field sketch of the scene.
I'm going to try to skip over the next few minutes because it's just him taking pictures and whatnot. Let's see. 23.
Are you going towards, Chesapeake, or are you going out away from Chesapeake? Towards Chesapeake. Okay. Okay. Alright, let's see. No, it's not raining anymore. Alright, step on that while it's not raining hard real quick. Okay, watch your front of the car, watch your step back. Alright, stand right here for me. Stand. Listen, I'm trying, man. Alright.
Right there at the end, what did he say to you?
He said, listen, I'm drunk.
I didn't, can you repeat that after me?
We'll play it again.
Say one day. Yeah, my left leg. What's wrong with it? Well, listen, I'm trying, man. The car, watch your step back. Alright, stand right here for me. Stand. Listen, I'm trying, man. Alright.
Say it again what he just said to you.
He said, listen, I'm drunk.
Got hurt.
So at this point, you go into the conducting some field sobriety tests.
Yes.
At that time, did you feel that you had reasonable suspicion that he might be impaired to drive for purposes of the OBI statute?
Yes.
So I want you to go back from the point that you first arrived on the scene until this point and kind of recap all of the things that you had put into your mind as reasons why he might be impaired that formed reasonable suspicion.
The time of night, the crash, and when I made contact with him, I asked him if he had anything to drink. He admitted to drinking. And then when we walked over to the vehicle, detected the odor of alcohol emitting from him, as you can see in the video. Then when I fast forward, when I get him out, then he admits to me that he is drunk.
Now, are you trained by the Highway Patrol to conduct standardized field sobriety tests in accordance with the standards of the National Highway Traffic Safety Administration?
Yes.
That's part of your credentials to be a highway patrolman, is that right?
Yes.
I had you review some papers that I'm going to mark as State's Exhibit 1. Field sobriety test stuff. I'm going to ask these pages?
Yes.
What are they?
That's this NHTSA manual session 8, revised 2023 edition.
And are those the instructions that you use during when you are taking a class in how to perform field sobriety tests?
Yes.
And you're familiar with these pages?
Yes.
And you know them to be an accurate representation from the manual itself, is that right?
Yes.
Class exhibit 1.
Any objection?
No, sir.
Be admitted.
So do those pages in the manual explain the procedure for conducting standardized field sobriety tests?
Yes.
You're familiar with them, you know how to conduct the tests in substantial compliance with the standards?
Yes.
All right. Now, before you start actually doing the test, do you ask some preliminary questions to figure out some things as to whether there might be limitations on the person's ability to perform the test successfully?
Yes.
What kinds of things did you do that in this case? Did you ask them some questions?
Yes.
And what kinds of things did you ask them?
I don't remember the exact words I used, but I asked him if he wore glasses or contacts. He stated he did not. And I asked if he had anything that would impair the ability to walk a straight line today or stand on one leg. And he said yes.
And we'll talk about that, but did you do the horizontal gaze nystagmus test first?
I done the making sure both eyes tracked equally and the make sure pupil sizes were the same.
Okay. What I'd like for you to do then is explain to me, first of all, what is nystagmus and what is horizontal gaze nystagmus and how that applies to your investigation.
It's the involuntary movement of the eyes when alcohol or some other drugs are in play and someone's impaired with those.
So you have a procedure that you follow to determine if there's horizontal gaze nystagmus in a person that you're testing?
Yes.
I would like for you to explain the procedure that you use with a person when you're conducting that test.
So first it starts out at lack of smooth pursuits, which is it looks like windshield wipers on the driver windshield as the eyes do not track smoothly to a stimulus at that point. And then it's horizontal gaze nystagmus, horizontal nystagmus at maximum deviation. And held for no less than 4 seconds. And it's the involuntary jerking of the eyes when it's at maximum deviation. And then the prior to 45 is the bouncing of the eye prior to 45 degrees, the involuntary movement again.
Did you conduct this test here in this case?
Yes.
Alright, so, just like now. Alright, so, we're blessed with contacts. Okay, have any injuries? I've been very good at the wall straight line today.
Yeah, my left leg.
What's wrong with it?
I had a knife go through my leg when I was 5 years old. And I have to put on my weight on my right leg.
Okay, do you have like a doctor's or everything that says that you have a... I'll still put that in the statement in the rule.
Yeah.
If it comes down to it, okay? But it's in my hand, folks, your eyes only, don't move your head, you understand?
Yep.
Okay, don't move your head. What I want you to do is take your hands and all the fingers like this. Go on top of the chin. I just help you keep your head still, okay? Stay still, okay? Oh, if your eyes only, don't move your head, you understand? Yeah. Follow. I'll fall back on you. Follow him.
can't see that far.
Follow the pen, just look at it, move to the pen.
I can't see that far.
Yes, you can.
I can't move my eyes that far.
Look at the tip of the pen, follow with your eyes.
I can't.
That's what we're up with, okay?
Did that just show you doing the horizontal gaze and nystagmus test?
Yes.
While you were conducting this test, did you notice any other possible cues that that this gentleman might be impaired by alcohol?
Not focusing on the stimulus, and he was swaying.
Did you notice his eyes at that point, other than the nystagmus? Did you notice maybe any other thing about his eyes?
All the bloodshot loss.
And I'm going to show you what Pat Martin's States Exhibit 2 information, and ask you what that document is.
This is our HP 7, which is an impaired driver report.
And is that a impaired driver report prepared as part of this case?
Yes.
And does it record your observations on the field sobriety tests?
Yes.
And did it record your observations on the horizontal gaze nystagmus test?
Yes.
And what did you report?
I saw 6 out of 6 clues, which that references distinct nystagmus, that maximum deviation in both eyes, lack of smooth pursuit in both eyes, and onset nystagmus prior to 45 in both eyes.
And is that what you observed this evening when you were
Yes.
performing that? According to NHTSA's studies, what is the percentage likelihood that a person will have a breath alcohol score of over 0.08 if they have at least 4 clues?
88%.
Now, there's also a place for vertical gaze nystagmus. Did you perform that test in this case?
Yes. It was not present at the time.
What else?
Board up with it, all right? Just hold your eyes right on. Don't get frustrated. All right?
Yep. Still, hands folded.
Yeah.
Like inside chin.
Yeah. Bring your chin down. Just go
Yeah,
down.
my chin, two up.
Okay. Like this, see how my face is?
Yeah.
Keep it straight. Sit to the pen.
Yeah.
Point of order, okay, well, 4:35 is Toby Pack.
All right. So is vertical gaze nystagmus another part of your training on the field sobriety tests that you use to conduct field sobriety tests?
Yes.
And did you see any additional clues of impairment when you did vertical gaze nystagmus?
No.
Now, would you normally move on to the walk and turn test next?
Yes.
And was there, did he perform that test?
He did not.
And why is that?
When he stated to me that he had an injured leg, I didn't really do the test.
Did he move on to another test?
Yes. He said he could stand on his good leg for the one leg stands.
We're down here, I'll bring this my car, and we'll do a few more tests walking around these hands, okay?
I can't do the walk like line thing with my left leg.
Okay, we'll do the one leg stand now, okay?
That's good with the right leg.
All right, that's fine. Let's go down here. Yeah, I'm trying to make sure you don't fall in this big hole here. All right. Let's stand right here. Shut the traffic down. Stand right here, just follow the flash. Right here, that's fine.
All right, so let's talk about the one-leg stand test. I would like for you to explain to the court how that test is conducted and also how you instruct the person to do the test.
You find a flat surface, the flat surface you find, and then you ask them to put their feet together, arms down to the side, as you demonstrate and explain the test to them. It's you bring your foot approximately whichever leg you feel comfortable standing on. You bring your foot approximately 6 inches off the ground, parallel to the ground. Keep your arms down to your side the whole time. Look down at your toe the whole time and count out loud in the manner of 1001, 1002, 1003. And after I'm finished demonstrating and explaining, I ask if they have any questions or if they understood. And if they say yes, they understand, I tell them that they may begin whenever they're ready.
Did you do that in this case?
Yes.
And did you make observations when you performed the test?
Yes.
And was it recorded on this impaired driver report?
Yes.
And what clues did you observe?
He sways while balancing and puts his foot down.
That feel pretty flat, even to you?
Yeah.
I mean,
Yeah.
Okay.
That's flat.
All right, so you say you cannot do the walking type test.
I can't do my left foot. Like, if you look at.
So you cannot do this right here.
I don't think that.
Okay, if you can, that's fine.
Not there.
Okay, that's fine, we won't do that test. All right, so this is going to be a one leg stand test, okay? We'll get whichever leg that you're comfortable with, all right?
Right leg.
Your right leg, so the best leg you're going to stand on. You're going to bring your foot approximately 6 inches off the ground, parallel to the ground like so, okay? You don't have to do that now, you can just watch my demonstration explain. All right, you're going to count the manner 1001, 1002, 1003, and so on until I tell you to stop, okay? Just to be honest with you, it's a 30-second time test. On 30 seconds since my watch, I'll tell you you're done, okay? All right? The objective is here to keep your foot the whole time. Do not stick your foot down, okay? Keep your arms out to your side the whole time. Look down at your toe the whole time. And if you do happen to put your foot down, say you're counting 1001, 1002, I put my foot down, I stopped, I put my foot down 1002, continue, lift it back up, go 1003, 1004, continue where you left off, okay?
Continue where I left off.
Yeah, do you understand all those instructions?
Yep.
Okay. All right, you may begin whenever you're ready.
2006, 2007, 2008, 2009, 2010, 2011, 2012.
All right, we're good. Now, we'll do one more adjustment.
Okay, so you recorded the results of your observations on the one-leg stand test.
Yes.
And what did you observe?
He sways while he's balancing, and he puts his foot down.
Is this an accurate copy of the impaired driver report that was prepared by you in this case?
Yes.
I'm going to ask that Exhibit 2 be admitted.
Any objection?
No, sir.
Be admitted.
According to NHTSA studies, what's the likelihood that a person is going to have a breath alcohol score of at least 0.08 if they show at least 2 clues on the one-leg stand test?
I don't recall if I was taking the 80%.
Can I have that Exhibit 1 back?
Yeah.
You're on this. I'm going to refer you back to page 53 of Section 8 of the 2023 manual that we've already admitted, and see if you can see the exact answer on there.
83%.
Did you move on to doing the modified Romberg
Yes.
test? Now, is the modified Romberg something that you also learned through your NHTSA training?
Yes, after we graduated our field training portion, we learned that advanced roadside impairment detection.
Is this a test that's primarily used for alcohol detection?
No, it's more used for drugs, but it's a good indicator for alcohol as well.
And is this something that you will do routinely during your investigations for every
Yes.
Now, I'm going to show you what I've marked as State's Exhibit 3 for identification and ask you what that document is.
It's the modified Romberg test. Manual.
Are those instructions on how you perform that test?
Yes.
And I would like for you to explain how you perform that test and what you're looking for, and also any instructions that you provide to the person who's taking the test.
During the, when we do the modified Romberg, you place your feet together, keep your arms down to your side, and tilt your head back. Close your eyes and tilt your head back. And estimate the passage of 30 seconds in your head, not counting out loud. When you're finished estimating that time in your head, simply raise your head back up, open your eyes, and say, "I'm finished." And that's when I'll stop the clock. What you're looking for at that point is swaying as he's doing the test or as they're doing the test. Eyelid tremors, looking for narcotics in the nose, anything of that sort.
Did you observe anything of note when he performed that test?
Yes.
Remember what you observed?
He finished a little faster than 30 seconds.
Was there any swaying or anything like that?
I don't remember.
All right, this one's set. Put your feet together like this. Put your arms out to your side like this. And then when you tilt your, what you're going to do, you're going to tilt your head back, close your eyes, you're going to count to 30 seconds in your head. You're not count loud, you understand? Yeah. All right. And when you tilt your head back, that's when I'll start to watch. When you finish counting, raise your head back down, say, I'm done. And I'll stop the timer.
So it's 30 seconds.
In your head, you're not counting loud. And when you're done, say, I'm counting, I'm done. Raise your head, I'm done. And I'll stop this timer right here, okay? All right? Whenever you tilt your head back, close your eyes. That's when I'll start the clock. Okay, how'd you count? 30. Count a little quick, thanks for that. 26. Okay, that's 4 seconds off. Plus or minus 5, so that's not too bad. But from the other things I was saying, I do think you're 2 pounds out of the vehicle, okay? Alright, and then place your hands behind your back like you're clapping. You're clapping. Can you do that? Like you're praying, if you can.
Let's have a prayer.
Yep. Ooh. You have shoulder problems or anything? How bad?
Not bad.
No, we're going to reposition your hands because I cannot get these around like that. Now, you don't want to hurt your, because I don't want to hurt your shoulders or anything. Yeah. Yep. I haven't seen that before. I'll sit back. Good? Yeah.
Okay, so at that point, had you placed Mr. Stover under arrest?
Yes.
And did you feel that you had probable cause at that point to arrest him for OVI?
Yes.
And I want you to go back and just recap how you reached that conclusion from the beginning.
Judge, I'm going to object his asked and answered until we get to the field sobriety test. I think if he wants to summarize those, it's okay. This will be the third time he's been asked to go back from the beginning now.
I mean, I'm going to let him do it, but it is maybe redundant. It's up to you. I mean,
Was there anything from the field sobriety test on that added to your suspicion that generated your conclusion that you had probable cause to arrest him for OVI?
The clues I obtained at the field sobriety test.
And I'm also going to go back and ask you if this, what I had marked as States Exhibit 3 are accurate copies from the NHTSA manual that describe the correct procedure for conducting the modified wrongdoing test.
Yes.
I'm going to ask that Exhibit 3 be.
Any objection?
No, sir.
You admitted.
Okay, so what time is it here when you place him under arrest?
11:30.
Did you also cite him for failure to control and failure to wear a safety belt?
Yes.
Did you offer Mr. Stover the opportunity to take an alcohol breath test.
Yes.
Got that? I'll show you what a marked States Exhibit 4, ask you what this document is.
The B&B 2255.
And what is that form for? What does it do?
It's for ALS suspension.
Is that something that you present to a person after they've been arrested for OVI?
Yes, I read it with a witness and ask them if they'd like to take a test. Most of the time in the manner of a breath test.
Does that document set forth what their obligations under the law are and what their rights are and things of that nature with respect to chemical testing?
Yes.
And you have him sign that?
No.
Was it witnessed by another trooper that you actually signed that or presented that to him?
Yes.
And that other trooper was which one?
Trooper B.
Is that an accurate copy of that 2255 form?
Yes.
And on there, does it, in shorthand, have you state the reasons for the probable cause of the arrest?
Yes.
And what did you write on there?
I wrote HEN 4511-202, which is failure to control, admittance, standardized field sobriety test, and odor, bloodshot glossy eyes.
And I'm going to ask that this exhibit 4 be amended.
Could be any objection?
No, sir.
You did.
Did he agree to take the breath test?
Yes.
Now, all of the video that we've watched here today, do you believe that it fairly and accurately represents what actually happened?
Yes.
I'm going to ask that the video, the parts that we played, be admitted as exhibit 5.
Any objection?
Just the rule of completeness, Your Honor, I'd ask that the whole video be admitted. Other than that, I would join Mr. Hill.
Yeah, we don't object to
Okay, then.
that. Did you transport Mr. Sorry, I can't remember his name. Stover to the Ironton Post for the breath test?
Yes.
Now, are you certified to operate the breath testing device?
Yes.
What is the make and model of that?
It's a Toxilizer 8000.
You're familiar with how to operate that because of your training?
Yes.
I would like for you to explain how that training goes, what you have to do, and what it takes to actually make the machine work.
The training is learning how to type in the data that needs to be entered into the name, address, my information need to operate the machine, and name, address of the other individual cells. And then it does a series of tests, and that's all I can.
Can just anybody walk off the street and run that machine? Do you have to have credentials?
Yes, yes.
And so do you have to punch something into the machine or swipe something or something in order to make it work?
Yes, I have to type in my VAs or toxinizer card number.
And do you have that number because you are trained and are a member of the Highway Patrol in good standing?
Yes.
And you're certified to use the machine?
Yes.
What happens if they decertify you? Would you be able to conduct such a test?
No, I no longer work anymore, and I won't be able to get the same machine.
What number are we up to?
5 was last.
5 was the last.
The video.
All right. I'm going to show you what's marked in Exhibit 6 and ask you to identify that document.
That is my VAC number, my access card number for the toxinizer.
And that shows that you are certified. I'm going to ask that Exhibit 6 be admitted.
Any objection?
No, sir.
You admit.
Did Mr. Stover take a breath test?
Yes.
When the breath test is done, is there some sort of a report that comes out?
You have your blood alcohol count.
This is the subject test report. This is State's Exhibit 7. I'd like for you to identify that. What is that?
Oh, that's the test result sheet for the VAC.
Is that from this case?
Yes.
Does that appear to be an accurate copy of the test report from this case?
Yes.
And who was the testing officer on that?
That would be myself.
And at the bottom there, is that your signature?
Yes.
What was the test score?
I object, Your Honor, to lack of foundation at this point. This officer has testified he punches data into the machine and it runs some tests. I don't believe that's sufficient for that document to establish the actual test score.
Overruled.
What was the test score?
0.204.
Now, was that over the limit of .08?
Yes.
Was it also over the limit for a high score of .170?
Yes.
All right, I want you to, I guess you've already kind of explained that you, I'd like for you to give some more detail about how the test is actually conducted. You've already explained some things, that you put a code in to access the machine, and then how do you know it's ready for a person to submit to the test?
Well, the screen will tell you that it's ready. Then you put the mouthpiece on and it takes the breath sample. I don't know the inner workings of the machine because we're not required to know the inner workings of the machine.
I understand. All right. Now, if there is an error during when you're conducting the test, does it show up on that sheet?
It would.
Were there any errors in this case?
There were not.
What is the final time listed at the end of the test?
It would be 12:16.
12:16 a.m.?
Yes.
And is that April 3rd?
Yes.
Now, you already testified that you arrested him at about 11:29 p.m. So was this test just a little bit more than an hour after you arrested, maybe an hour and 7 minutes after you arrested?
What time did you say I arrested?
11:29. Well, it's not even less than an hour, is it?
Yeah, less than an hour.
So 11:29 to 12:22. Now, So the test, was it given within 2 hours of when he consented to taking the test?
Yes.
And after you put him under arrest, did you observe him continuously for 20 minutes directly before him taking that test? To make sure that he didn't ingest anything?
Oh, yes.
It's alleged in the motion that the tank pressure was below the standard. What was the tank pressure when the test began?
At 424 PSI.
And what was it at the end?
At 422 PSI.
If there were a problem with the tank pressure, would it cause an error in the testing and abort the test?
Yes.
Were there any errors at all?
No.
And is this a fair and accurate copy of the actual report?
Yes.
I'm going to ask that the State's Exhibit 7 be administered.
Any objection?
Yes, sir.
Go ahead. What is it?
Just the same objection, Your Honor. The basic foundation has to be that the machine is functioning properly before you get to that report. You've heard none of that. There's insufficient foundation to accept that report for the value, the evidentiary value in which the state's offered it.
There's plenty of cases now that say if there's boilerplate general objections not specifically designed for a problem in the evidence, the state only has to give general evidence. I find that to be the case here. So I'll overrule your objection.
Let me just preserve the record on that issue, Your Honor. I think it's important. The suppression motion was filed pursuant to the rule on May 8th. This breath test discovery that the state provided me wasn't provided until June 12th. So at the time I filed this motion, I've got to make those allegations. I mean, I don't believe I have any duty to, when the state gives me late discovery, to adjust my suppression motion. I mean, it's...
You do. I think if you want to get into specifics, then you have to set forth those. You can take it to the Court of Appeals and they can decide that, but that's my reading of the current law.
Your Honor, I have here the Ohio Department of Health documentation going back, I don't have any years, but the required number of years, all that 2020 back here, showing every test that was performed by the state of Ohio on this particular machine. This information was provided to the defendant as quickly as we could. We have to subpoena it, and it gets sent to us, and then we make copies of it and send to them. So we think we did all that in a timely fashion, and these are all certified copies. And I believe that they're self-authenticating and show that there are no errors. In addition, in discovery, we provide a link to the website on the Ohio Department of Health website that actually allows them to access these records, even though they're not certified copies, they're still accurate records online. They can look those up the day that the person gets charged. So I think that, first of all, that these are admissible to show that in general we met our burden of showing that the machine was operating properly. We'd like those admitted.
Okay. I don't know if that's Exhibit 8.
That's just what I've been told by all the experts in the courtroom that bring these motions.
Your Honor, let me object to that also. I mean, at some point, the defendant's got a right of confrontation. Just because those records are offered doesn't give them any value that they are what they say that they are. I mean, those might be accurate copies. Mr. Heald represents that they're certified. There are certification pages on there that are not attached. The documents themselves are not certified. There's a certification page that follows each one, doesn't identify what record it's certifying. We has a right to confront anybody on that list. I mean, the court, I don't think, just takes those and says, okay, they're admissible. I mean, where is the authentication procedure? If the document themselves were authenticated, that may be different. If these records were from the Bureau of Motor Vehicles or the Department of Health, that would be a different story. What you have is the Department of Health saying these are true and accurate copies in our possession. That doesn't make them accurate as far as to the content, Your Honor. They may be true and accurate copies, but you don't, what he wants you to do is take judicial notice that the content is accurate. That's what I don't think you can do, Your Honor. So let me make sure, my understanding was if the state wants to admit this stuff, there has to be at least one time an expert come down here and walk through the records. At that point, the court could say, I can take judicial notice of what these records mean. But to my knowledge, that's not been done. And that's what he's asking you to do, Your Honor. So just note my objection. That's all I got.
Okay. I don't think you need to respond, and I don't think that is correct. And what has been happening with these motions is boilerplate gets filed, and then the defendant wants to jump in on any particular thing that's not proved. But that's, when you object to everything, as one court said, you object to nothing. If you're not going to specifically say, I find these are problems with the evidence, that's what a motion to suppress is supposed to be. The defendant looks at the evidence and says, Judge, I think there's some problems with the evidence you need to look at before we ever get to trial. But that's not what these are turning in to be. They're boilerplate motions. They want the state then to prove everything about the case before we ever get to trial. And that's not what this is designed for. And we got Court of Appeals decision that say when that's the case, the state only has to give general evidence. And I find that's the case here. So I'm overruling your objection. I'm omitting Exhibit 8. If I'm wrong, the Court of Appeals can tell me. Proceed.
Thank you, Your Honor. I think I've admitted everything that needs to be admitted, 1 through 8.
Through 8.
So if not, I'm asked they all be admitted, and that's all the questions I have in this witness.
Okay, they're admitted. And before, we got a lady that's been sitting torturously watching all of this. So I'm going to take her case before we do cross-examination.
Oh, I still have another witness also.
Okay, well, we're going to do it now, and then we'll come to your other witness.
Is this something you need me in the courtroom for?
No, you guys want to take a break? It's not going to take very long.
State of Ohio versus Lily Howard, case number TRC 211513, AB to state.
Okay, this is set for, I think it was set for sentencing. I've got September 16th.
What was the case number 21? Excuse me.
1513.
Yeah, I have it down.
You got it down what?
I have it down.
We'll just be here on this side.
Well, the file is written, maybe it's a mistake. I think it said August 16th.
Your Honor, I'm sorry, I can explain that.
Okay.
The treatment agency contacted me. She's getting ready to complete and want to move the hearing up.
Okay.
Yes. So I had it set today.
I have her last drug screen if you'd like that.
And your report or anything you got. Just want to
I apologize, I've been out sick and I didn't get time to get the report in, but I can send one to you as soon as I leave here. Yeah. I did grab her last year in spring.
So she's completing treatment?
Yes, Your Honor, if it's in agreement with the court and probation.
Yes.
Can I say something real quick?
Sure, go ahead.
Okay, so she also, we have an aftercare plan for her, and she volunteered to come and do outpatient with me being her counselor because I'm outpatient Monday, Tuesday, and Wednesday, and then I work inpatient Thursday, Friday, and Saturday. So she chose me because we already have, like, I know all about her past, and she's made great progress since, I've been working with her. We touched base a lot on relapse prevention and avoiding toxic people, places, and things, and high-risk situations. And I can continue to bring progress evaluation letters if you'd like, with her being an outpatient. And also yesterday I took her and she got the Vivitrol shot.
Okay.
I'm sorry, my voice, I've been sick both times I came to court here. I get my throat so sore.
And she's living in Lucasville?
Yes, 532 Fairground Road, but she will be moving to her residence on Lick Run Lyra.
Yeah.
And that's in
Southwest.
South Webster, Ohio. And we will provide transportation to go get her once
For
she's
outpatient?
in, yes. And I can bring her to any, like to report or to court if she has to come back.
Okay, I'll allow her to finish up there and transition to outpatient. And do you have a way of doing online appearance? Do you have a smartphone?
Yes, yeah, we can Zoom.
Yeah. Let's just keep the September 16th date and allow it to be by teleconference.
Okay.
So she doesn't have to come in person.
I can give you the information to get on.
Okay, and what time is that, Your Honor?
We'll make it for 9 a.m. and then she has probably some restitution, I'm going to say, because the amount that was owed was large, so I think she must owe money to someone for damage to her vehicle or something.
She's been paying $50 a month, she said. Yeah, you'll continue to pay.
Yeah.
She's going to do that today too?
I get paid on the first of the month.
She gets paid one time a month, Your Honor.
All right, September 16th is our next hearing.
Okay, thank you so much and have a good day.
You too. Yeah, we're ready. Start back.
If you want to go along with their own, to the,
Yeah. He wasn't back. Okay. I need to get back up there.
Okay, so we're ready for a cross-examination. Trooper Barnett, so Mr. Eaches, you may proceed.
Thank you. Good afternoon, Trooper Barnett. My name's Mike Eaches. I represent Jared Stover in this case. I'm going to ask you what probably will seem like a lot of questions. If you don't hear me or you don't think one makes sense, just tell me. I'll try to make it clear what I'm asking you. What all did you do to prepare for today's hearing?
I read my statement and a few aspects of the Section 8 manual.
Meet with Mr. Heald?
I did not. Well, briefly, before we walk in.
Okay. Have you watched the video?
I did not watch it before coming to it.
Okay. You prepared a statement of facts as a result of this incident, correct?
Yeah.
And that document begins with when you were dispatched and basically ends with a description of the citation that you wrote. Is that fair?
Yeah.
Is that statement of facts in chronological order, meaning that you recorded the events in the order in which they happened?
Yes, sir.
And Mr. Heald showed you some exhibits of the February 2023 NHTSA manual, correct?
Yes.
When did you receive training, or did you receive training, I guess I should ask you, on that manual, the 2023 manual?
The 2023 manual, we had to They sent out we call it an IOC in her office communication. They sent that out saying it's been revised, so we was all sent a link to look at it. So I was trained with the 2018 version. Had to look over the 2023 version.
Okay. So fair to say you have not received any training on the 2023 manual?
Not with like classroom training aspect. It'd be more of looking at it myself.
No instructor told you about anything in the 2023 manual?
Correct.
So your extent of familiarity with the contents of the 2023 manual is a review of a link online?
Yeah, of the session 8.
Okay. And you did observe Mr. Stover's vehicle in motion?
I did.
And you were dispatched to a rollover crash?
Yes.
I thought you testified that the vehicle was on its side when you arrived.
I did this.
The vehicle was on its top, correct? Yeah. Okay, so I just want to make it clear it's on its top.
Yeah.
Okay. And you were dispatched at 10:57 p.m., correct?
Yes.
And it's a rural area?
It is.
And do you have evidence as to the amount of time that passed from when Mr. Stover had this accident until it was reported resulting in your dispatch?
I only have from the time I'm dispatched to the time I get.
You didn't conduct any investigation to see if there was any delay in the dispatch process?
No.
Okay. And when, I think we heard it on the body cam footage, you came from another accident straight to Mr. Stover, is that true?
From the body cam, yes. I don't recall the events of that happened prior to that.
And you testified that it was raining very hard that night?
It was.
And Mr. Hield asked you and established that you arrived on scene around 23:10, which would be 11:10 p.m. Does that sound right?
Yes.
Your Honor, may I approach the bench and grab the state's exhibit?
Sure.
The subject test form, please.
Here. Yeah, it should be. Those are all good.
Judge, I think that's it. Got it. Trooper, I'm going to show you State's Exhibit 7. That's the subject test form, if I'm correct. Is that what it is?
Oh, yeah, yes.
Document's very important. I mean, it has the breath test score. That's an issue. Right.
It is.
Okay. And it says on there, if I understand this right, it says time first observed, it says 22:57 or 10:57 p.m.
So I put that's the time I was initiated or sent the incident to go. I didn't physically observe Mr. Stover at that time, but I always put the time I was dispatched because that still, with the 3-hour window.
But sir, you agree with me that that document says time first observed. It means the time you first observed Mr. Stover.
Yes.
I mean, that information is false, right?
If you go by that, yes.
Okay. You guys see that? Sir, are you aware of any other information in this document that's not accurate?
Not that I know of.
For example, where it says the date of last certification of the machine. Do you have any independent knowledge as to whether or not that's accurate?
I don't deal with that aspect of it.
And same thing in terms of the dry gas standard and so forth, as to expiration date and so forth. Do you have any information regarding that?
I don't have any information.
Concerning those other issues, other than the time, you can't be responsible for information that you don't know, right?
Correct.
You didn't put the expiration date and all that stuff in that form. That's not the data you entered.
No.
When you arrived on scene, prior to making contact with Mr. Stover, you spoke to a fireman. You asked the fireman, is he drunk, right?
Yes.
Fireman didn't have any information that Mr. Stover was indicating clues of impairment.
He did not.
And when you first made contact with Mr. Stover, he explained to you how the accident happened. We heard it on the video, correct?
Yes.
And his explanation matched the evidence you saw on the scene, correct?
Yes.
And you asked Mr. Stover if he had anything to drink tonight, correct?
Yes.
And when Mr. Heald asked you that, he inserted the word alcohol in there. When you asked Mr. Stover, you didn't say anything about alcohol, right?
No, I just asked him, have you had anything to drink tonight?
Okay, and he responded yes.
Then I asked how much. Well, no, not that one time.
You didn't ask him how much at that point, correct?
Not that one.
Didn't ask him what type of alcohol he drank? Right?
No.
Didn't ask him how long it had been since he'd had a drink?
No.
Didn't ask him what type of alcohol he had been drinking?
No.
And according to your statement of facts, you had not recognized the odor of alcoholic beverage at this point, correct?
When I asked him?
Yes, sir.
No. You just see in the video when I recognized.
Right, and the video shows the first time that you detected the odor of alcohol because you commented on it, correct?
Yes.
Okay. We'll come back to that. But when you did notice the odor of alcohol, well, let me strike at you, Your Honor. And that would be the same as far as the bloodshot glossy eyes. Those were recognized as you were beginning to perform the horizontal gaze and nystagmus test, correct?
Yes.
So at the time that you, as soon as Mr. Stover told you, yes, in response to your question, have you been drinking tonight, you at that point told him that you're going to run him through field sobriety testing.
Yes.
So your decision to administer field sobriety testing was based on the fact he had an accident and the fact that he responded yes in response to your question about have you had anything to drink tonight?
Yes.
And the next thing that you did was pat Mr. Stover down and lock him in the rear of your cruiser, correct?
I got him out of the rain.
Okay, but by locking him in the rear of the cruiser?
Yes, he was in the back seat.
But he can't get out of the back seat, can he?
He cannot.
Okay. You told him that you were going to have him sit in your cruiser for a second because you had a few things to do. Does that sound right?
Yeah.
And you say it's to get him out of the rain, right?
Well, yes.
Okay. And Mr. Stover was standing in the rain when you first arrived on scene, right?
Yes.
He didn't make any complaint to you about, I'm soaked, or anything. He didn't say or do anything that should have made you believe he was uncomfortable in the rain.
No.
And you didn't give him the chance to continue, the option to go ahead and stand out in the rain, right?
I don't think so. No.
And When you first told Mr. Stover to have a seat in your car, he approached the front passenger door, correct?
Yes.
And you directed him and said, oh, no, it's the back.
Yeah, he would have been able to sit in the front if I was with him, but I have stuff in the front that didn't allow it.
And when you put Mr. Stover in the back of your car, you didn't tell him, beat on the window if you need to get out.
No.
You didn't tell him any way that he had to get out of the back of that car, correct?
No.
And I'm not trying to beat this to death. There's no door handle for him to let himself out of the back of that car, correct? Okay. So he's in your custody at this point. Do you agree with that?
No.
Okay. If he wanted to go sit on the guardrail, could he have done so?
Yes.
How?
By asking.
Okay. So how would he have done that? How would he have asked you?
Can I sit on the guardrail?
I mean, how's he going to get your attention?
Beating on one. Or saying, hey.
Okay. So he's not being detained at this point?
At that point, the only matter for that detainment would have been for the crash event. He still wasn't free to leave due to the crash.
Okay, so he wasn't free to leave. We agree there?
Yes.
Okay. And in terms of the urgency of this crash investigation, there was a single car accident with no injury, correct?
That's true.
And traffic was still flowing by the scene.
I believe there were a few cars that came through. If I remember correctly.
And you didn't tell Mr. Stover when you put him in the car, hey, you're not under arrest. I just want you to hang tight here, right?
I did not.
Okay. And Mr. Stover remained locked in the rear of your cruiser for 7 minutes and 48 seconds. Does that sound right?
I don't know the exact.
May I approach the operation?
Why don't we just stipulate it's 7:48? Are you going to?
Well, I think that'd be great.
I don't know if it was exactly 7:48, but I mean,
Okay.
Well, no, what I'm saying,
I represent to you in 7 minutes and 48 seconds.
I mean, it's fine.
Okay.
God. Whatever. If it
I'm
was
not on you,
6
let's move this along.
Good. 5 minutes and 27 seconds.
Representatives here.
So are we actually going to fight over whether it was 7:48 or something else?
You know, I'd stipulate that it was
He's
amount of
stipulated
time
7:48.
around 7.5 to 8.5. How about that?
Okay. And you have session 8 in front of, you don't. May I approach again, Judge?
Yes.
Chip, I'm going to show you State's Exhibit 1, and hopefully just have you hang on to it for a while. I'd like you to look at page 12 of Session 8, please.
Like 12 pages over or the actual page number?
Page number 12.
Start at 23.
Okay, let me give you Defendant's Exhibit 1. I didn't bring any stickers, Judge.
Got some for you.
Thank you.
What, do you want me to put some? You ready?
Hey,
Hey.
State's got the numbers.
Okay. Yeah, I got one.
Thank you.
You're welcome.
I return this to the judge, page you go on Mark the State's Exhibit. Super, does that appear to be the full Session 8?
It's Defendant's Exhibit A.
Defendant's Exhibit A. Does that appear to be the complete
Yes.
It's the first time you've ever seen a complete Session 8?
The complete Session 8? No.
No?
No.
Okay. And what I want to ask you is about these field sobriety tests. Mr. Heald asked you about the specific percentages from the validation studies. You remember answering those questions?
Yes.
And on page 12 of Session 8, it says that validation only applies when the tests are administered in the prescribed standardized manner, right?
Yes.
And it says if a single deviation from the NHTSA protocol may compromise the validity of these field sobriety tests, correct? It's the last sentence.
Yes, right.
So, do you believe that you administered this HGN test in substantial compliance with the NHTSA regulations?
In substantial, yes.
Prior to administering the HGN, you asked Mr. Stover if he has any injuries that would impair his ability to walk a straight line, right?
Yes.
That's not what you were trained to ask before the HGN test, is it?
I was just get a pre-medical assessment or to see if they'll be able to perform the HGN, not HGN, but the standardized field sobriety test.
You're trained to ask questions about the subject's eye and general health conditions, correct?
I feel like that was a pretty general question.
What was?
Can you walk a straight line? Would anything impair your ability to walk a straight line? If someone asked you that.
Okay, well, if he has an injury to his eye, is that going to affect his ability to walk a straight line?
No.
If he's a diabetic, is that going to affect his ability to walk a straight line?
It could.
Okay. You didn't ask the question you were trained to ask about his eye and general health conditions, did you?
No, I just asked if he had glasses or not.
Okay. And he tells you that he has a left leg injury.
Yes.
And you asked if he had a doctor's note. He didn't have one.
That's true.
Okay. And among this HGN, how many separate steps does NHTSA require for the systematic administration of the HGN test?
I believe it's 9 or 10.
Do you know?
It's 10.
Okay, what are they?
Pre-medical. Checking for slow pursuit. Checking that the eyes track equally. Checking that the pupils are the same size. Lack of swim pursuits. Maximum deviation. Prior to 45. Add your clues up. That's vertical at the very end. I'm drawing a line.
Okay, you're free to take a look at page 25 if you need to. You were trained to give 5 verbal instructions before administering the actual test portion of the HGN. Is that correct?
Check vertical tracking, lack of swim pursuit.
Page 25.
It starts with 24.
Matt,
It starts with, what you're talking about starts with 24, page 5, 25.
No, what I'm talking about is on page 25. Take a look at step 2 on page 25. It's titled Verbal Instructions. Do you see that?
Yes, I see.
It contains 5 verbal instructions there. Do you see that?
Yes.
Trained to instruct the subject, put your feet together, hands at your side.
That's the first one.
You agree you failed to give Mr. Stover that instruction?
Put your feet together, hands to your side, yes.
What's the significance in the validation of the HGN test with a subject having their arms to their side and feet together?
The significance?
Yes, sir.
As long as they stand still with their head not moving, I don't think that does with anything.
Okay. Trained to instruct the subject to keep looking at the stimulus until told the test is over. Do you see that instruction?
Where did you say that was at? That's the very last one. Keep your looking at the stimulus.
Do you see that?
I do.
You agree you didn't so instruct Mr. Stover?
I did not.
Okay, so do you agree you gave 3 of the 5 initial verbal instructions?
Yes.
Okay, it's about 60%?
Yes.
Okay. I want to just take you through this HGN test. I don't know anybody to do this fast.
Hey, what's up? Straight one today?
Yeah, my left leg.
What's wrong with it?
I had a knife in my leg when I was 5 years old, and I have to put on my weight on my right leg.
Okay, do you have like a doctor or everything that says that you have a... Okay. I'll still put that statement in the rule. Yeah. If it comes down to that, okay? But take my headphones, your eyes on, don't hear it.
Okay, I'm going to have you watch a section from 14:11 to 14:21 on the video. I'm going to ask you some questions.
No.
Yeah, you understand?
Yeah.
Okay. What are you looking for at this point?
That's just to make sure the eyes track equally and the pupils are the same size.
Okay. So you don't claim to observe any clues of impairment during that portion?
No.
And do you recall stopping the HGN test at this point and instructing Mr. Stover to interlock his fingers, place his hands on top of his chin? Do you recall that?
Yes.
And that instruction and the resulting position is not part of the NHTSA HGN protocol, correct?
No.
A matter of fact, having your hands up under your chin is about the opposite of having them down to your side, isn't it?
Yes.
So according to what NHTSA says about one deviation can compromise the validity, we're already there, aren't we?
I'm going to object because I just don't think that he's in a position, well, I'll withdraw that objection.
Right.
You can answer.
Well, what was the question again?
The question is, when I showed you about where NHTSA says one deviation may compromise the validity, we've certainly had more than one deviation up until this point, correct?
Yes.
Okay.
Is that on page 12?
I want to, take you to 1435.
Okay, now move your head. What I want you to do is take your hands and all the fingers like this. Go on top of the chin. I just have to keep your head still, okay? Stay till my head. All of your eyes on me. Now move your head. You understand?
Okay, I want to watch a couple passes here and ask you some questions.
Follow.
Okay, what are you doing at that point?
That would be Langston pursuit.
Okay, you were trained to start with Mr. Stover's left eye, correct?
It doesn't matter which side you start with.
Okay. Okay. I would like for you to look at session 8, page 30. Midway down the page, it says, for standardization, begin with the subject's left eye.
It does say that.
Okay, you're telling me it doesn't matter?
Would that be strict compliance or substantial compliance?
That would be for his honor. You didn't start with the eye NHTSA tells you to start with, did you?
I did not.
Okay. And if you look at clue number 1, page 31, when you're looking for clue number 1, move the stimulus smoothly all the way out to the right, checking subject's left eye first. Do you agree it says that?
Yes.
And you didn't do that, did you?
I did not.
And doesn't NHTSA also say to check the other eye and instead of checking the same eye twice?
You re-advise that
Yes.
person.
There's never any portion of the NHTSA protocol that would ever have you checking the same eye twice without checking the other eye in between. Does that make sense?
Yes.
And you agree with me that you checked his right eye twice?
I don't agree with that.
Okay.
Sure, one day.
Yeah, my left leg.
What's wrong with it?
I had migraines in my leg when I was 5 years old.
There's no way I can.
Sure, one day.
Yeah, my left leg.
What's wrong with it?
I had migraines in my leg when I was 5 years old. And I have to put on my weight on my right leg.
Okay, do you have like a doctor's or everything that says that you have a... I'll still put down the statement and we'll...
Yeah.
If it comes down to that, okay? But it's in my hands on with your eyes and your eyes on, and don't your head, you understand?
Yep.
Okay, don't move your head. What I want you to do is take your hands and roll the fingers like this. Go on top of your chin. I just have to keep your head still, okay? So it's in my hand. Hold your eyes on, you don't move your head, good?
My question, Trooper, is whether or not you checked Mr. Stover's right eye twice without checking his left eye in between. I want you to watch this.
Follow.
Is that what you did?
I did do that motion, but he wasn't following the stimulus, so I didn't check it twice.
Okay. On these 2 passes on the right eye, do you claim to identify any clues?
One pass on the right eye. Yes, Alexis Kane.
Okay. One more. I want you to watch from 1441 to 1451.
I'll fall back on you. Follow me.
What are you looking for during these passes?
Which passes?
The 2 we just watched.
At that point, I'm still doing Alexis pursuit.
Okay. I want to watch from 1451 to 1457. I'm going to ask you some questions.
Yes.
You're looking for distinct and distinct nystagmus and maximum deviation at this point, correct?
Yes.
And you're starting with the wrong eye again, correct?
Yes.
And you're also checking his right eye multiple times without also checking the left in between, correct?
Not correct.
Okay, what are you doing?
He's not keeping his eyes on the stimulus, so I'm not able to check that eye because he's not focusing on the stimulus.
Okay, so none of these passes result in a clue is what you're telling me?
Not when he's not focusing on the stimulus.
Okay, so he wasn't focusing on these passes?
Every time I stop and tell him to refocus, he's not focusing.
Okay.
I can't sit up.
Yes, you can.
I can't move my eyes up.
Look at the tip of the pen, all with your eyes.
So none of these passes result in clues?
Yes.
Correct?
Correct.
Okay. At this point, you're looking for onset prior to 45 degrees, correct?
Correct.
Start with the wrong eye again, right?
Yes.
When you locate the angle of onset, are you able to see the whites in Mr. Stover's eyes?
Do you re-ask that question?
Sure. When you located the angle of onset, were you able to see the whites in his eyes?
I don't remember.
Okay. Would you look at page 50, please? Hold on a second. Wrong. Page 36.
Not 50?
No, sir. See where it says you should, usually some of the white will be visible? It's about midway down the page.
Yep.
And you don't recall if it was or not, correct?
Nope.
Okay. And, see that? When you look for this angle of onset, you're looking for jerking of the eye, correct?
Yep, involuntary movement of the eye.
When you're conducting this onset of nystagmus prior to 45 degrees, after you first detect a slight jerking in Mr. Stover's eyes, what's the immediate next step?
You go to the other eye.
Okay. Is that what you did?
So I guess, yes.
Okay. Let's give that back to you. According to your training, sir, page 51, after you first detected a slight jerking in Mr. Stover's eyes, you're to stop moving the stimulus to make sure that the jerking continues. Is that your memory of your training?
What was that question?
You were trained to stop, when you first detected a slight jerking, you were trained to stop moving the stimulus to make sure the jerking continued.
I don't know.
Okay, well, just read it.
Page 51.
Yes, sir.
It says keep both legs straight.
Page, my numbers might be off. Page 37, third paragraph. When you see the eye jerk, stop moving the stimulus. Hold it at that position and verify the jerking continues. See that? Page 37, I'm sorry. I don't know how I got into 50s.
When you see the eye jerk, it's not okay. Yes.
That's what you were trained to do, correct?
Yes.
Okay. Now, nothing in your report that I saw indicates that you performed the vertical gaze nystagmus test.
You're correct.
Okay. And is that because you observed no clues of impairment?
Yes.
So when you give these tests, if you don't claim to see clues of impairment, you just exclude them from the report?
It's on the impaired driver sheet. I was wrong on that.
I'm sorry?
I was wrong. It's on there, but it's not on there. The box is not checked. Yeah.
Okay. Is that the reason it's not mentioned in any report on your narrative, your statement of facts, because there were no clues?
Yes.
Okay. And Mr. Hield asked you some questions about the validation studies, correct?
Yes.
Were any of those conducted in the pouring rain?
No.
And you were aware that Mr. Stover had just been involved in a rollover crash, correct?
Yes.
Probably fair that none of the test subjects for the validation studies had been in an accident?
That's fair to say.
Are you familiar with rotational and post-rotational nystagmus?
When you're done spinning.
I'm asking if you're familiar with those as you were trained in NHTSA.
Yes.
And how did you exclude rotational or post-rotational nystagmus for the nystagmus you observed, the cause of the nystagmus you observed?
By the time I arrived on the scene, well, you can say I didn't do anything. You re-ask your question.
Sure. I'm asking you how you were able to exclude rotational or post-rotational nystagmus as what you were seeing during the HGN test.
I don't know.
I guess what I'm asking you, there's no difference between the nystagmus that you say you saw and rotational or post-rotational nystagmus. It all looks the same. Right?
Correct.
Now, you never asked Mr. Stover if he hit his head in this accident, right?
That's true.
And you cited him for not wearing a seatbelt.
Yes.
Do you agree it would be impossible to have a vehicle on its top, unrestrained driver, not bump his head in some fashion?
Somewhat, but nothing impossible.
Well, that may not be the best question, but if the vehicle's upside down and he's unrestrained, his head's got to make contact with something, right?
There's chances, yes. There's more chances of it happening than it not happening.
Fair. Did you notice a red mark on his head?
I don't recall.
Now, Mr. Heald asked you, with the HGN, says that as some type of clue of impairment, that he was not focusing on the stimulus and was swaying. You remember that testimony?
Yes.
Neither of those are clues recognized by NHTSA for impairment on the HGN test, correct?
No, they're observations. So yes, they're just observations.
But you testified that you considered them to be clues of impairment.
They're indicators of impairments.
Okay. Go ahead and take my full session 8 and show me where swaying and not focusing on the stimulus has anything to do with alcohol impairment.
It's divided attention, it's not focusing on stimulus.
So is it your testimony he's intending not to focus on the stimulus?
Intending? No, I didn't say that.
Well, if he's not able to focus on the stimulus, that's not divided attention, is it?
Stand still, trying to focus on the stimulus.
Okay. Sir, let me go back at this again. I would like for you to show me anywhere in your NHTSA training where swaying and inability to focus on the stimulus has anything to do with impairment, indications, observations, anything whatsoever. I mean, did you want to look?
What was that, a question? Or
Yeah.
you want me to show you?
I want you to show me where you received any training whatsoever that the HGN has any clues other than the 6 validated clues that we have discussed.
The HGN, there's only 6. The HGN only has 6 validated.
So the swaying and the inability to focus on the stimulus, according to your training, has nothing to do with alcohol impairment.
I wouldn't say nothing to do with alcohol impairment. They are not certified clues. They are indicators of impairments.
They're not mentioned whatsoever in any of your training materials, though, is what I'm asking you.
Okay.
Well, how did you, wait a minute, Mr. Reed. Mr. Heald's not objecting, but I gotta say, look, NHTSA is not the holy grail. Only what's in NHTSA can be considered. That's not correct. So go ahead and ask your questions. Other things can be considered other than what are in NHTSA.
From where did you form the belief that swaying and inability to focus on the stimulus were indicators of alcohol impairment?
Training.
Okay. Training other than NHTSA training?
Okay, move on. I've had enough. This isn't helping me. Let's move on. Common sense is not left outside, okay? Common observations are allowable. Let's get on with this.
Okay. You didn't administer the walk and turn test because Mr. Stover told you he had a leg injury.
That's correct.
And for the walk and turn, you were trained that during the validation studies, people with back, leg, or inner ear problems have difficulty performing the walk and turn test.
That's true.
Okay. And when we come to the one-leg stand test, you were trained that people with back, leg, or inner ear problems had difficulty performing the one-leg stand.
That is correct, but I asked him if he was able to do the test, and he stated that he could with his good leg.
Sir, aren't you the person with the training to determine whether or not a person's a suitable candidate for these tests?
I can't be in that person's body. I don't know how injured they are if it comes down to that. If he believes that he's able to do it, then he's able to do it.
Isn't it true, according to your training, if you're not medically suited for one, you're not medically suited for the other?
I don't recall.
Okay? Take a look, please, at session 8, page 49. where it says people with leg problems have difficulty performing the test? So finally, the same criteria is used to determine whether a person's a suitable candidate for the one-leg stand and the walk and turn.
He stated the exact what it is.
What's the answer to my question?
They are the same.
The location where the one-leg stand was performed was not reasonably dry, was it?
It was not.
Okay. And you were trained to initiate the one-leg stand test by giving some verbal instructions, correct?
Correct.
First instruction being, please stand with your feet together and your arms down to your sides, correct?
Yes.
You failed to give Mr. Stover that instruction, correct?
Yes.
Second, do not start to perform the test until I tell you to do so. Is that an instruction you were trained to give?
Yes.
Do you agree you failed to give Mr. Stover that instruction?
Yes.
You were trained to instruct him. Do you understand the instructions so far?
Yes.
Do you agree you failed to ask him that question?
Yes.
Now, Mr. Stover started this one-leg stand test a little bit early, correct? You want to see it on the video?
But are you talking about the portion where I told him not to start yet?
Yes, sir.
Is that where we're at?
Yeah. Let me withdraw that. You were trained to instruct a subject when I tell you to start.
Yes.
And you didn't instruct that to Mr. Stover?
Not until I was finished demonstrating, explaining.
And you were trained to instruct a subject while holding that position, count out loud, correct?
Yes.
And you didn't tell Mr. Stover to hold that position while he counted, correct?
I did not.
And you're trained to instruct a subject to keep both legs straight during this test, correct?
Yes.
Agree you didn't give that instruction to Mr. Stover?
I don't recall.
I'm sorry?
I don't recall.
Understood.
Fine, we won't do that test. All right, so this is going to be a one-leg stand test, okay? You'll pick whichever leg that you're comfortable with, all right? Your right leg. So that's the leg you're going to stand on. You're going to bring your foot approximately 6 inches off the ground, parallel to the ground, like so, okay? You don't have to do that now, you can just watch my demonstrate and explain. All right, you're going to count the manner 1001, 1002, 1003, and so on until I tell you to stop, okay? Just to be honest with you, it's a 30-second time test. When 30 seconds hits on my watch, I'll tell you you're done, okay? All right? The objective is here to keep your foot the whole time. Do not set your foot down, okay? Keep your arms out to your side the whole time. Look down your toe the whole time. And if you do happen to put your foot down, say you're counting 1001, 1002, I put my foot down. When I stop, I put my foot down on 1002. Continue, lift it back up, get 1003, 1004. Continue where you left off, okay?
Continue where I left off.
Yeah. Do you understand all those instructions?
Yes.
Okay. All right, you may begin whenever you're ready.
Okay, we agree you didn't tell him to keep both legs straight, correct?
Yes.
Okay. And you told Mr. Stover you're going to be honest with him, and this was a 30-second test, correct?
It is.
That's not one of the NHTSA instructions, is it?
It is not one of them.
Same thing with telling him the objectives to keep his foot up at all times. That's not a NHTSA instruction, is it?
That is not.
And you instructed Mr. Stover to look down at his toe, correct?
Yes.
And were you referring to the toe on the ground or the toe in the air?
The one there.
No way for him to know that, was there?
No.
And you were trained to give the instruction to keep watching the raised foot, right?
Correct.
But okay. And you instructed Mr. Stover, if you do happen to put your foot down, lift it back up and continue, correct?
Where you left off.
Yeah. And you were trained to only give this instruction during the one-leg stand when the subject had put his foot down. Is that correct? Take a look at page 52. Midway down page 52, if the subject puts the foot down, give instructions to pick the foot back up again. Do you see that?
I'm on the wrong page. I do see that.
So you gave an instruction that's not supposed to be given until after he puts his foot down. Agreed?
Yes.
Okay. And when, during the one-leg stand test, Mr. Stover did put his foot down, correct?
He did.
And you did not give him the instruction to pick his foot back up and continue on, correct?
I don't believe so.
I want to ask you some more about this modified Romberg balance test. Mr. Heel gave you a portion of the A-RIDE manual as session 5. You recall that?
Yes.
I'm going to show you State's Exhibit 3 and ask you if that's the NHTSA A-RIDE modified Romberg protocol.
Yes.
Now, that chapter 5, session 5 is titled Observation of the Eyes and Additional Tests for Drug Impairment, correct?
Yes.
Did you have any evidence Mr. Stover was on drugs?
I did not.
You testified in response to Mr. Heald's question that the modified Romberg is a good indicator for alcohol as well.
It can be.
Point me to that training where you learned that, whether it be from NHTSA or some other source.
It's the duration of time. If you're impaired, the duration of time can be messed up. Which, in my A-RIDE class, they did say you can use it for alcohol as well.
Yeah, I'm just asking you to point me to it.
I can.
Nothing at all in the A-RIDE manual says anything about this test relating to alcohol, correct?
Not that I'm aware of.
Okay. And the NHTSA A-RIDE manual lists 11 separate verbal instructions to be given to a subject during the administration of the modified Romberg. Do you agree with that? I'm looking on page 10 of session 5.
What's the header on the page?
Stages of modified Romberg balance test. It's page 10.
Not this one.
Sorry.
The balance stage.
Sorry, I didn't realize you didn't have that one on mine. For B.
For B.
Thank you.
You're welcome.
All right, I'll give that back to the judge. Here, so we'll give you my copy. And ask you if that appears to be the complete section 5 of the Wright manual.
You say page 10. Oh, yes.
And page 10 is what I'm interested in. Where it talks about 11 instructions. You see that?
Yes.
You agree there's 11 instructions?
No.
The video evidence will determine how many of those instructions you gave, correct?
Yes.
Okay. And Mr. Stover estimated the passage of 30 seconds in 26 seconds, correct?
That's correct.
So his body clock was 4 seconds fast, correct?
Yes.
Alcohol is a depressant, right?
That's true.
Alcohol would be expected to slow down a person's body clock, correct?
True.
Okay. And the results of Mr. Stover's estimation of time indicates he was not impaired, correct?
I don't agree with that.
Okay. Take a look at page 12, please. Very top. Research has indicated a non-impaired subject's time estimation will typically be within plus or minus 5 seconds of 30 seconds.
You said page 12?
Yes, sir.
Okay, I see.
So do we now agree that Mr. Stover's result on his time estimation would indicate to you, according to your training, he was not impaired?
As you said, the modified Romberg is not a test for alcohol.
Well, but
I don't agree with that.
But you agree that's what the manual says?
The manual does say that.
But, okay. Now, you also claim that Mr. Stover swayed back and forth during the test, correct?
Yes.
You were trained, or were you trained, I guess, in order to record swaying, the officer must estimate how many inches the subject swayed.
Yes.
You didn't do that, did you?
No.
And NHTSA, this modified Romberg in the ARIDE manual, mandates that you record 4 major items that need to be recorded for the modified Romberg test, correct?
Yes.
You recorded 1, right?
Yes.
And that's his time estimation.
True.
After the modified Romberg, you arrested Mr. Stover, correct?
Yes.
And at what point in the encounter did you make the decision to arrest him for OVI?
After the HGM.
Okay. I want to ask you, you testified that you hear Mr. Stover tell you that he's drunk on the video, correct?
Yes.
And is it your testimony that you were aware of that on the video prior to today?
You re-asked that question.
Sure. on the scene that night, you didn't recall Mr. Stover making that statement?
On the scene?
Yes, sir.
No.
Okay. So in this investigation that you conducted, that statement wasn't part of it?
After rewatching the video.
Understood. I'm asking at the time of this incident.
I don't recall.
Sir, if a subject would tell you that they're drunk and you heard it, it would be in your statement of facts. We certainly can agree to that, can't we?
Yes.
Okay. So, okay. And prior to putting Mr. Stover in your car, you didn't administer Miranda to him, correct?
Not prior.
And in fact, you waited a fairly substantial time after his arrest to administer Miranda to him.
Yes.
Now, I want to ask you, Mr. Heald asked you some questions about the 2255 form.
Yes.
And you read that to Mr. Stover when he was seated in the rear of your cruiser, correct?
Yes.
And this 2255 form, you swear to the accuracy of the information contained in the form, correct?
Accuracy. Yes.
Okay. Well, Judge, my approach, you get that exhibit, please.
Yes.
I'm going to show you State's Exhibit 4. And you checked the box that Mr. Stover refused to sign the 2255 form, correct?
Yes.
You swore to that fact, right?
Yes.
Is that the truth?
I don't know.
I'm going to show you what I'm going to mark here shortly as Defendant's Exhibit 4, or B, C, D, I believe. I got it all filed out.
What's the next sentence? I know there's an A. What else is there?
What she has right here is C would be next.
Okay. I think that's right. I got two digits of both, I'm sorry, both manuals.
They're right here. A and B here.
C.
You need a D?
You just didn't see where you're writing on here. Thank you.
You're welcome. And then there's your hand.
That's yours.
Oh.
I'm going to show you Defendant's Exhibit C and ask you if that's the 2255's form you served on Mr. Stover.
Yes.
And the box is not checked that he refused to sign the form there, is it?
That's true.
So this 2255 form was not sent to the Bureau of Motor Vehicles until sometime on April 5th of 2024. Is that correct?
Yes.
Is the extent of your knowledge concerning this breath test entering data in and telling the subject to blow?
You revise that question?
Sure. Is the extent of your knowledge concerning the Intoxilizer 8000 Post 44, is the extent of your knowledge about the workings of that machine that you enter data and instruct a subject to blow?
Yes, I enter my information, his information, and machine does its test, and it goes through, makes all the function checks.
And Mr. Hill, I'm sorry, sir, go ahead.
None of the, there was no errors that popped up at the time on the machine, and then when it instructed to place the mouthpiece inside the tube to take the breath sample, with no errors on the machine.
In order for the machine to properly recognize an error, the machine would have to be functioning properly, correct?
Yes.
The machine would have to recognize an error, correct?
Yes.
So if the machine's not functioning properly, it may not record an error, correct?
I'm going to object that he's not required to understand how the machine, what the science of the machine is, only that what the report is.
Sustained.
Do you have any responsibility concerning maintaining any of the instrument certification reports, maintenance reports, or repair reports?
I do not. I just have to annually recertify the machine.
Have you done that in 2024?
It hasn't came up to my time. I can't recall. It's either I've done it very early and I don't remember, or it hasn't came up to my time yet.
Well, according to Mr. Hill's exhibit, State's Exhibit 6, it says that you're proficient through March of 2024. Agreed?
That could possibly be the date that I recertified on the machine.
You don't have any independent knowledge of that as we stand here today, correct?
No.
So, Trooper, do you agree that the only way that you would know if this intoxilizer was not functioning properly would be if it spit out an error report?
Yes. You
have had breath tests that resulted in no .02 agreement, correct?
.02?
Yes, sir.
I have.
Okay. And what's the cause of that?
They could be user malfunction, or like I said, I can't tell you the workings of the machine.
Sir, do you agree with me that you personally have had some issues with the machine at Post 44?
I've had before. I've used it regularly.
No unusual behavior from the device itself?
Not that I know of.
Do you remember arresting a lady named Amber Logan?
I'm going to object. All of the records of the machine testing and recertification and all the inner workings of the machine are in those records that we've entered into evidence that Mr. Eaches has had since June. And I think he would, instead of asking the trooper, he would refer to the records themselves to look for malfunctions and things of that nature, because they're in those records.
I'll let him answer if you recall.
If I could just respond to that objection, Your Honor.
I overruled it, so why don't you respond?
There's nobody to cross-examine, Your Honor. This is all I got.
I'm glad you asked the question.
Okay.
But I do not recall.
Okay, I understand. Let me just back up. Do you know the instrument certification dates before Mr. Stover's test and after his test?
No.
Well, you know the minimum breath volume that results in a sufficient sample?
Not off the top of my head.
And Mr. Heel made a mention that my motion mentions tank pressure. You recall that?
Yes.
What's the minimum tank pressure for the machine to function properly?
I don't know that.
And the machine would have to function properly to know the tank pressure was too low, correct?
I can't answer that question. I don't know.
Almost finished. Have you seen the operator's manual for the Intoxilizer 8000?
Yes.
You familiar with the contents?
Yeah, it's been a while since I've looked at it, to be honest.
Okay, almost finished. When you've been asked some questions about the subject test form, correct? You still have that?
I have the 2055s. And your manuals.
I want to ask you, where it talks about Mr. Stover's result, do you see where it says capital B, lowercase r, capital AC?
Yes.
What's that mean?
I couldn't tell you off the top of my head what the R's are.
You see where it says 210 liters? You see what I'm talking about? Right past his result, it should say 210 liters.
Oh, okay, there.
210 liters of what?
And I'm going to object again. I don't think this is material that he's required to know in his job. And second of all, the motion did not tell us that this was going to be an issue, that we would have had somebody from the Ohio Department of Health that was qualified to testify if we knew that this was going to be an issue.
He can answer to what he knows. If he doesn't know, he's welcome to say that.
You did not follow, you didn't follow any written checklist of activities during this breath test, correct?
No.
Is there a special designation for the Intoxilizer 8000 used in Lawrence County? For example, is it Intoxilizer 8000 Ohio-1-2? Are you familiar with any of that?
What was the question?
I'm asking you if the Intoxilizer at Post 44 has any additional designation specific to the state of Ohio or your post.
I'm not understanding the question.
Understood. Mr. Heald asked you some questions about the passage of time from when you arrested Mr. Stover until he provided the breath sample. Do you recall that?
Yes.
And I want to back it up a little bit to the time of the accident. And I asked you a couple questions about this, but you answered that you don't have any evidence as to how much delay occurred from the accident until it was reported. Is that true?
That's true.
You testified, Mr. Heald, finally, Mr. Heald asked you if you constantly observed Mr. Stover from the time of his arrest until he provided the breath sample. Would you recall that question?
Yes.
Is it your testimony that you constantly observed him?
I'm going to object. The question was continuously for 20 minutes immediately preceding the test.
Sustained.
That's now my question. Is it your testimony that you constantly observed him for 20 minutes prior to the breath test?
That is my testimony.
Okay. And if in fact that were not true, the video evidence would show that?
Yes.
All the questions I have. Let me just get the exhibits back to the court. I'm going to move to admit, I believe, all the defendant's exhibits.
So that's A, B, and C.
Yes, sir.
Any objection?
No, Your Honor.
Correct.
I have no other redirect, Your Honor.
You step down.
Call Nick Kuhn.
How long do you anticipate? Because I'm not going to.
Very short.
It's going to have to be, because I'm going to be leaving shortly.
Free to leave.
If you're not going to plan on recalling, he's free to go.
Well, Judge, I don't know anything about this next witness, so I mean, if he's got somewhere he's got to get to, that's one thing. But if you just stick around until this witness is over, I'd prefer that.
I just haven't been asleep, so.
Sorry.
Would you raise your right hand? You swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You may be seated.
Nick, state your name.
Your Honor, I'm just going to object to this witness. I got some late discovery on Wednesday, which I'm prepared to deal with. No disclosure of this witness that I'm aware of.
We provided it to you, right, on Wednesday, or whenever it was, as before today.
The documents, yes. No notice that the witness was going to, you had a witness.
Well, is there some, educate me, is there some requirement that it be disclosed before today, the witness?
Maybe not, Your Honor.
Okay. Go ahead.
Your name and where you're reporting.
My name is Nick Coons, and I'm the 911 coordinator at Lawrence County 911.
In that position, are you the keeper of the records of calls that are made to the 911 in Lawrence County?
Yes, sir.
We're here today about an incident on April the 2nd, 2024 involving Jaren Stover. Are you familiar with that, and did you retain documents and audio recordings related to Jaren Stover?
Yes, sir.
And did you provide those to the Lawrence County Prosecutor's Office?
Yes, sir.
Prior to the hearing today, did you review the records and listen to the recordings so you could familiarize yourself?
Yes, sir.
What number?
We are on the 9.
I'm going to show you what I've had Market States did and ask you to identify that.
This is the call detail report, or what we call a CAD sheet, based on the initial call into the 911 center about the accident.
Is that relating to Jaren Stover?
Yes, sir.
So would that document show the time in which the first call relating to Jaren Stover and his car wreck, when it first came in?
Yes, sir.
And what time does it say that it first came in?
It would be, the call was, they began to enter the call into CAD at 22:55.
Now, when it began to enter into what?
CAD, or computer-aided dispatch system.
Is that contemporaneous with the call?
Yes, it would be immediately after they answer the phone.
22:55. Is that right?
Yes, sir.
So that's 5 till 11,
Correct.
Florence County 911.
I'm in the Municipal, and there's been a car wreck on Big Branch.
Okay, is it your courthouse?
Yes.
Okay, what's your address?
My address is 1133 Chesapeake, Ohio.
1133 what?
Chesapeake, Ohio.
And what road?
Big Branch Road. It used to be on the corner, upside down.
Okay. Okay, what is your name?
My name is Shannon Lewis.
The car on the top?
The car inside is upside down.
It's upside down? Okay, I'll get everybody that way.
Thank you, thank you.
Right.
Bye.
Mr. Coon, first of all, is that an accurate recording that you kept in the official records of 911?
Yes, sir.
And to your knowledge, is Big Branch, is that County Road 31?
That's correct.
Did Mr. Jared Stover call himself?
A caller identified as Jared advised that he had wrecked. I believe he was the third caller that we received.
Florence County 1.
No, I didn't break my truck.
Are you hurt?
No.
Okay, are you on County Road 31? Big Branch?
Yeah.
Okay, alright, look, everybody coming to you. What's your name?
Jared.
Alright, we're coming to you.
Alright, thank you.
You're welcome.
Now, in reviewing that, did you listen to that before court today?
Yes, sir.
And in reviewing that, did you hear any indication of when he said the wreck happened?
He said he just wrecked.
And what time did that call be recorded?
That would have, can I refer to my other call, my call sheet?
Sure. It's also on here.
Okay. That'd be 22:58.
22:58, so 2 minutes before 11.
Yes, sir.
And that was on April the 2nd, right?
Correct.
On both of those recordings, are those authentic recordings that were kept in the normal course of the 911 business?
Yes, sir.
So those are on that list there. I'm going to ask that those be admitted also under the same.
They're already on
They're
8.
on- Yes.
Any objection?
No, sir.
That's all I have.
Yes, sir. Sir, my name is Mike Eaches. I represent Jared Stover. Was Jared Stover the third person to call 911?
Yes, sir.
And none of the first two callers claim to have seen the accident, correct?
Correct.
Do you have an explanation for Mr. Stover said he just wrecked and 2 people had called before him? How would they not have seen the accident?
I have no idea, sir.
So when Mr. Stover used the term, "I just wrecked my truck," do you know how much time he's referring to? And I mean, I know what words he used, but do you have any evidence to when the accident occurred? Is what I want to ask you.
No, sir.
Okay. And were all 3 calls in a relatively short period of time?
Yes, within a few minutes of each other.
Okay. And you didn't ask any questions as far as to Mr. Stover, as far as when the wreck occurred or any of that?
No, that wouldn't be typically our protocol. I also wasn't the call taker.
Okay.
On any of these calls.
Okay, that's all the questions I have.
Nothing else, but we want to admit that last, the 911 document.
No objection?
Be admitted, that's 9.
Yes, Your Honor.
Anything else?
That's all, Your Honor.
Anything from the defendant?
No, sir.
Okay, so it's going to be considered submitted. I know Mr. Eaches he likes to write briefs, so he's going to write one on this.
I'd like it, yeah, in a transcript, Your Honor. I can formally request that in writing.
Okay, before you do the brief?
Yes, absolutely.
Well, here, let me give you a heads up of you threw me for a loop there at the end because, listen, I'm drunk, man. I had that written down in quotation marks because I'm thinking, all this other stuff, what difference does it make? But then the officer testified he didn't even hear that or consider it. So now that brings all the other stuff back into more focus as to whether he really had probable cause, because that was big. That's an admission. That wasn't considered to form an opinion as to probable cause, according to the testimony. So, I guess the state should go first since they got the burden of persuasion, and then you respond to that. But you want a transcript before you write.
I think I have. I just think that's the way to do it, Your Honor.
Okay. It's not going to be cheap, Mr. Saber.
Neither is the alternative, Your Honor.
Well, that's true. That's true. Any further comments?
Just for clarification, so you're going to want the state to show what other than his admission led to the probable cause for the arrest?
Correct, because I think the admission's out now. Unless you can, if you got a case that says, well, you can go back and rely on evidence that you didn't consider at the time that you're formulating your opinion, I'll be happy to look at that, but off the top of my head, I'm going to say, no, you got to consider the evidence, even if it was there, but you didn't consider it or didn't see it. I don't think you can go back and do a 20/20 hindsight and consider it, but if you got a case that says you can, I want to see it. So it's probably going to take us a month to get a transcript, I would say.
Yeah, Judge, I'm about to be out, way out of town for a couple weeks. It's defendant's got the time. I'm carrying the time burden. I understand that.
Sure. Well, why don't I do this? We have so many cases here. I don't like to just let a case lay without a date on it because then it can get lost. So why don't I put a date on this as like a pretrial, and then we can see where we are at that point and what we need to adjust. So I'm going to say maybe more than a month, and it's not going to be for evidence or anything. Actually, we could just do, you could even call in or teleconference or something. The defendant doesn't have to be here. I'm thinking the 20th of September maybe. That's a good date.
I see no problem with that Friday, Your Honor.
And why don't we set it again for noon? More likely we'll be able to deal with it then. I'm going to set it as a pre-trial status conference. And hopefully, what I'm hoping is like, we got the transcript, and now we'll set up a date as to when the memos are going to be submitted.
Yes, sir.
Okay, anything else?
No, Your Honor.
Thanks for coming. I'm sorry you probably had to sit around for quite a while. Same for you to go home, try to get to sleep. That's possible. You have to go in tonight, midnight?
Oh, yeah, I'm back out tonight.
Well, I used to do that when I was going to college, but I hated it. I was not good at it. I would sleep like 3 or 4 hours and worry how bad I was going to feel that night because I only slept 3 or 4 hours.